Majority, please, our motion is ready. We will file it before we get back next week, and we pray that you, the majority in Parliament, will fully cooperate with us, the minority. Something must be done. We need money for the hospitals. If government says there's no money to complete the Agenda 111 project, if government is still borrowing, yet it can find 22 billion, and this 22 billion, according to the IMF, is vanished into thin air. Sikana ira, sikana she, sikana wahe. Intanya atem didie. Yesre, ye juma. Yesre Ghana mine. Munta yechi. Nebe bia 22 billion wono. Ye nya ye nhwehwe. Enye personal attack, enye obi ene sebi ye jealous, and ye time no ene ye nebi. This is a complete policy failure. Goldbod. Yesre mu enye atem didie. Mumbe yi mano. Na ekano mutu mutaya mabaka. Telling you a Kukwanense story. If all was well, why are they taking these steps? In fact, the Goldbod chief executive said the IMF itself did not understand the transaction. He said publicly that he thinks the IMF doesn't understand. All the economists at the IMF, he said they didn't understand. He accused my friend KOJO Oppong Nkrumah, who did BCom at KVAS, that KOJO doesn't understand accounting. I did BCom. Of course, I abandoned NISAM along the line and did my law program. But KOJO completed his BCom. BCom is accounting. He accused KOJO that he doesn't understand accounting. He said this on TV3 program. Then he went on to attack our colleague, the chartered accountant, former Minister of State at the Finance Ministry, and chair of the Public Accounts Committee, a fourth termer in Parliament, Honorable Abna Oseyasare, also accused her. Then I took the last hit. But what the Goldbod chief executive has forgotten is that when initially the fees were around 15%, and the minority raised the first red flag, and the press conference was held by our respected colleague Oppong Nkrumah on our behalf, there was an immediate emergency board meeting, a joint emergency board meeting by Goldbod and Bank of Ghana, and they quickly reviewed the fees to 9%. That was the first point of vindication of the minority. According to them, we are ignorant. If we were that ignorant, why is it that when we raise a red flag, the 15% that they were charging, they reduced it to 9%? That was the first point. And when we escalated it through a motion on the House floor, they now went further and reduced it to 5%. So the question is, all those initial losses, now we want to put away IMF, all those initial losses, if the charges were legitimate at 15%, why didn't they remain the way they were? So the minority must be commended for saving the public purse.
Afenyo Makin and his followers have consciously chosen to disregard the Auditor General's confirmation that Goldbod did not record an operational loss. They now claim that the Auditor General did not have access to the full picture concerning the operations of the Goldbod. This position, ladies and gentlemen, betrays either a crass lack of understanding of how an external audit is conducted, or a deliberate determination to undermine yet another independent state institution, independent constitutional body, when its findings do not suit their mischievous narratives. I invite you, the media, you who are the fourth estate of the realm, to check the claim with the Auditor General, and you will come to the conclusion that officials of the Auditor General were given unhindered access to all relevant information in the conduct of their audit of the 2025 financials of the Ghana Gold Board. All documents requested by them were supplied, and all queries raised by them in their management letter were satisfactorily answered. This is why not a single, and I repeat, not a single adverse audit finding was made by the Auditor General in its 2025 audited report on the Gold Board, not on imaginary or hallucinatory losses, not on procurement breaches or breaches of the Public Financial Management Act. Not a single adverse finding was made against the Gold Board in the report of the Auditor General on our accounts for the year 2025. Afenyo Markin and his followers alleged on several occasions on the floor of Parliament and in the media that the Gold Board made losses in its gold trade operations in the year 2025. This claim is a barefaced lie, which has been debunked time without number by the Gold Board. The audited annual reports and financial statements of the Gold Board for the year ended December 31st, 2025, prepared and published by the Auditor General of Ghana, discloses an operational surplus of 907 million Ghana cedis and an overall surplus of profit of 5.4 billion Ghana cedis. This is an incontrovertible fact. And today, to settle this matter once and for all, I brought to this auditorium a copy of the annual report and financial statements of the Gold Board, prepared and published by the Auditor General, not Sammy Gyamfi and the Gold Board. We don't audit ourselves. Now, if you check page 12 of this report, you will see that the Gold Board on its own, from its own operations, generated total revenue of close to 1 billion Ghana cedis and kept expenditure just around 109 million Ghana cedis. And so that is what we mean by operational profit or surplus of 907 million. It means that if you took all the revenue we generated as an organization and you deducted our expenditure from it, we had 907 million left. Now, because in the 2025 budget statement, government budgeted a revolving seed capital as its equity for the newly established Gold Board of 4.5 billion Ghana cedis, which monies hit our accounts on or about 30th of December 2025. Those funds had to be added to the revenue of the Gold Board because they were not encumbered, they were not depleted, they were not dissipated. And that is why the overall surplus is 5.4 billion. And this reporting was done by the Auditor General, which puts to rest the false claim that the Gold Board has been making losses.
Well, good morning and welcome to Current Agenda, your Saturday morning companion. Before I started, you could see some videos on the screen, some of the issues that have come up within the course of the week, most topical of all being where our money is gone, whether there is a loss or there is no loss. And this morning, 3 big stories which we will put before you, we will put under the microscope, we will look into the details. We are looking at issues on law, we are looking at issues on the economy, we are looking at issues in terms of housing. We will interrogate the facts and push to understand beyond the narratives that we have. So What are we serving this morning? Well, first we will serve you. When I say serve, I mean you understand what I mean. We will serve you with the discussions on the Goldbod. I hold the book with me. The chief director showed us this book, so we will be discussing the issues in the Goldbod and BOG trading issues. Who is saying what, and whose issue is the right issue to discuss? Who is right? Trading losses, P&L losses. Who are we supposed to listen to as the people? Now, these are things that have far-reaching implications for us as a people. And when we talk about these issues, it's not just any issues. Like I mentioned first, we look at Ghana's justice system. We are looking at public finance issues and then housing issues. Now, in terms of the judiciary, remember the issue about courts and judges going on leave we discussed last week. Well, the Supreme Court has taken a decision on the case that was presented to it, the injunction to prevent certain courts from sitting. The interlocutory injunction that was filed by the Ofuansi MP KOJO Oppong Nkrumah has been dismissed. In the ruling by Justice Gabriel Scott Poorman, he said that the applicant failed to make a compelling case for the injunction. Now, this decision has paved way for other affected courts to sit under the administrative warrants that were issued by the Chief Justice within the period. However, it's important to note that what was dismissed was the interlocutory injunction and not the case itself, not the substantive case where Honorable KOJO Oppong Nkrumah is challenging the constitutionality of the warrant that is given, and he says that it is discriminatory and it does not treat all people the same, and says that it breaches Article 17 and 296 of the 1992 Constitution, and that, he says, is selective justice, is discriminatory. Now, what does this ruling mean for the administration of justice? What does it mean for the independence of courts? What does it mean for the freedom of people? What does it mean in terms of issues bordering on discrimination or fair treatment? Now, when we move from the judicial system, we move straight into the economy, into finance. And then we know we are talking about the Bank of Ghana and the Goldbod under the Ghana Domestic Gold Purchase Program. Now, we had the Goldbod Chief Executive, Sammy Gyamfi, who has dared the minority leader, Alexander Afenyo-Markin, to invoke Parliament's oversight powers and summon him so that he comes to respond to the allegations of massive financial losses. Now, the minority claimed that the state's gold trading operations have incurred losses of 22 billion, rightly to say that the minority referred to the statement in the IMF report. Now, Mr. Gyamfi rejects this assertion and describes this claim linking Goldbod to the reported loss as inaccurate and misleading. He says that at the center of this dispute are critical questions that we also need to understand. Both sides are throwing, but who bears the responsibility for the alleged losses? And what exactly happened to these funds? And will Parliament secure a clear and credible account? Remember, there's been an earlier attempt to summon the chief executive that was stopped by the majority. Will it happen this time so we as the people would get the true answers that we deserve? Then finally, we will shift our focus to one of the long-standing housing projects in this country, the Saglemi Affordable Housing Project. Now, the president of the land, President John Mahama, says that the first 700 units will be completed and commissioned by March 2027. And by the end of the year, there should be about 1,500 units available. That is the target for the end of the year of 2027. Now, this announcement is a long-waited for announcement because we know what has happened with this Saglemi project. It's been inactive, it's been quiet, it's been still for a very long time. But government says that safeguards are now being put in place to prevent further losses. And government is urging all prospective homeowners to prepare for registration. But the question to ask is, after all these years of delays and controversy, will Saglemi finally be completed? And the daring question, will the homes truly be affordable for the ordinary Ghanaian? Well, these are the issues this morning we would have under the microscope to try and understand. My interest is in the last one, whether we will really have affordable housing for us all to purchase. But don't go anywhere. Stay by your television set, stay by your radio. This morning, my partner and I would go into details and make meaning of the troubling questions you have on your mind. We'll be right back after this break.
From the heart of Africa we stand, building dreams across the land. Every step we take your side, helping you rise, taking you higher. Strong as a group, close as a partner. Bank of Africa lifting you higher. African Bank with global reach. BOA make your future glow. Strong as a group, close as a partner. Bank of Africa lifting you higher. African Bank with global reach. BOA make your future glow. BOA, we go there for you night and day. Strong as a group, close as a partner. Bank of Africa lifting you higher.
Bank of Africa, as strong as a group, as close as a partner.
Well, welcome back from the break. This current agenda is proudly sponsored by Bank of Africa and the NPA. So this morning on my reflections, I would speak to the recent issues about nationwide blackouts. Now, Thursday morning, I woke up and then somewhere around 4:30, lights went off. Now, what happened on Thursday is not the first. The Gridco reported that there was a major fault on the Akosombo Volta transmission line, and that single fault tripped the Akosombo generating units and some other parts, and that resulted in the power outage. Tripped the Akosombo generating units and some thermal plants. Now, this resulted in a nationwide disruption, and that is what is worrying for me. Not to say that this was an isolated issue. This has happened again and again. If you remember, 3 weeks ago, around July 29th thereabout, there was a similar nationwide disturbance, and the issue given or the excuse given is similar. So within a month, this country has suffered 3 major blackouts. And that is a concern And the energy security, the Institute for Energy Security has actually even flagged this, that for a country to have 3 major blackouts like this in a month has become 1 too many. Now, we had the issue with the April fire at the Gridco switchyard. You remember the one that the president, when they eventually promised somebody employment. And then that forced an emergency transmission arrangement and raised uncomfortable questions. Questions including claims of possible sabotage. If you remember, some claims were being made that certain people from the former administration or in the opposition people were the ones doing this. Investigations came in, there were speculations, but the one question that is left unanswered is that our power system keeps showing vulnerability. It keeps showing vulnerability. Look, we can allow the engineers to throw all the jargons and terminologies at us. They can call it technical fault, they can call it a trip unit, they can call it whatever it is. That's them. But there are 2 sides to a blackout. There's what the engineers are saying, that's what we the people are feeling. To me, as a Ghanaian, as a citizen, this blackout means a lot to me. It means that there are business hours that I'm losing. It means that my equipment are at risk. It means that hospitals now have to run on backups. People's lives are at risk. It means that students are unable to study. It means that people who are supposed to trade to make incomes are losing. That is what it means to me. So the engineers can throw the jargons at us. They can tell us all those things and confuse us. Sitting where I'm sitting, what matters to me is that I am at a loss. I am losing. If I have things in my freezer, if I run a cold store, I am losing. I have to now go buy extra fuel to power a generator, I am losing. If I pass on that cost to my consumer, that consumer is losing. It is affecting us in that way. So they need to let us understand. If we are in the season where the most fearful power generation problems are sliding back, tell us. We can't be living in this unpredictable power situation. You need to let us know. You need to understand that restoring power is necessary. And what do we need to do to prevent the next collapse? We've restored it and everybody is going to sleep. What do we need to do to prevent the next collapse? And what is it that other developed countries are doing that they do not have this collapse, that we keep getting it over and over again? What must be done? What capital intensive changes must be done? We need to know. We are stakeholders in this economy, we are stakeholders in this country, so we cannot continue to be taken for granted. We need to be told the truth. Stop managing us and tell us the truth. There must be transparency. Energy analysts have asked questions. They have been blurred in the background, but we need to know whether the adequacy of information from Gridco is the truth and whether what they have been saying about these disruptions is accurate. We need facts. We don't need to face speculation. The country is not a trading ground for people to speculate, to change views. We need to know the facts. It's important. We cannot be running a system the way we are running. What happened in April, what happened in July, and what happened recently in August cannot be right, and we do not need to continue like that. We need a permanent fix, and we are going to keep asking for permanent fix. If the earth was meant to be dark, it would have been kept dark. If there is light, please let us enjoy the light. This is Reflections. I'll be right back after this break.
Back and stay safe. The National Petroleum Authority is cautioning the public to desist from scooping or fetching fuel from overturned fuel tankers at accident scenes. Do not get closer to the scene in an attempt to take videos or pictures. Inhaling the petroleum product is detrimental to your health. Worst of all, petroleum products are volatile and highly flammable, and a small spark can trigger a catastrophic explosion, causing deaths and loss of property. Call the Ghana Fire Service or Ghana Police personnel to handle the scene, or reach the National Petroleum Authority's contact center on 0302 550 380. Your life is worth more than a gallon of fuel. This Save a Life campaign is from the National Petroleum Authority.
From the heart of Africa we stand, building dreams across the land. Every step we dey your side, helping you rise, taking you higher.
Strong as a group, close as a partner. Bank of Africa lifting you higher. African Bank with global reach. BOA make your future glow. Strong as a group, close as a partner. Bank of Africa lifting you higher. African Bank with global reach. BOA make your future glow. BOA, we go there for you night and day. Strong as a group, close as a partner. Bank of Africa lifting you higher.
Bank of Africa, as strong as a group, as close as a partner.
Well, welcome back from the break. Current Agenda, your most authoritative news analysis and your Saturday morning companion. This morning we will serve it hot. So take this to be your coffee for today. We have in studio with me to my immediate left lawyer Austin KWABENA BRAKO-POWERS. He's a private legal practitioner. Senior.
KOJO.
Good morning.
KOJO, morning, and good morning to you.
Last week and this week, I like the shirt.
I'm just trying to, you started the thing, so we are just picking the pace. But it's troubling the rate at which our electricity gets ramping up. And you were articulated this so far almost 3
Yes.
since the start of the year. It's becoming troubling. And it's the explanation the minister gives is laughable. Because we want to see some concrete steps taken. And it's dangerous. You know what? It's dangerous in one front that if people want to attack you, they can attack that area. And I don't understand how we have centralized our energy production to the point that when there's no electricity, then everything goes off. It's surprising. And maybe this government must step up their work and get something doing, because we need a quick fix. And like you said, we need a quick fix, and the quick fix must not be a temporary one. It must be something that will last. True. The current generation.
I mean, how can we be generating power here for Western region? One source is generating.
That's it.
One person is the one doing the distribution.
It's dangerous. So we must be able to up our ante.
Anyway. So next to lawyer Powers, we have lawyer ISHAQ IBRAHIM, who is also a member of the NPP Legal Directorate and a lecturer at the UPSA Law School. Lawyer ISHAQ.
Yes. Good morning to you.
Celebrity.
Good morning to you.
Good morning.
Good morning to my colleagues here, and good morning to the good people of Ghana. I'm surprised about what Powers is saying that is troubling. I'm very surprised. You've forgotten that the incompetent one is actually in power. President Mahama. I mean, he was the one.
I didn't see this coming.
He was the one who made the Oxford Dictionary to add DANSO to his dissent. Me, it doesn't surprise me. I mean, do you realize that sometimes you buy 50 CDs and the 50 CDs will last 2 days? Then you buy 500 and the 500 will vanish in 24 hours. People have reported it. I am not sure why this is not really a scandal in the country. It's like somebody is stealing. So quite apart from power disruption, there's also a power theft ongoing. But I am not sure why. In fact, I have experimented it. 3 days ago, I bought 50 CDs. It lasted me 2 days. I've been buying 200, 300. 50 CDs. Yes, 50 CDs. You can look. I can show you.
You are too big to buy 50 CDs.
No, somebody told me to experiment it. Yes. Somebody told me to experiment it. In fact, this is a national scandal, but I don't know why people are not talking about it. They told me don't buy huge amount, buy small and see. I can show you. You can show it to the good people of Ghana. There's power theft going on by the government. I have experimented it. It's here. I'll show you the app.
But why are we saying it's by the government?
Well, who is? If there's good news, they take credit. Who would you attribute it to? They will come and tell you they have solved the problem. But aside claiming they've solved the problem, they are still in power. I mean, I don't understand it. Who is the right person to take to court? Maybe for me, the power theft is the one that needs to stop. Because I didn't. Do we have power tariffs? Okay. Or whatever the government wants?
We have to look into this, because if
they have to look into it.
And Lawyer is also saying that he has.
You see that?
I also have a similar experience.
You see?
Someone told me, stop buying 500 CDs, 300 CDs, and you start with 30 CDs and 50 CDs. And you would note that the 30 CD can even last for more than 5 days. Whilst the 300 CDs can sometimes less than 3 weeks.
And yet we have never communicated about this. I just said it now.
No, people have
been
people have been complaining.
Yes, there's power theft going on
in the media.
Who is stealing it? If somebody is stealing on ECG, they are stealing on behalf of government.
Right. Anyway, so like I said, we'll look into this.
Yes.
But we are going to start our discussions. I mean, it's been an interesting week.
Yes.
You would all know that last week we spoke about this issue about legal vacation.
Yes.
We heard that the KOJO Oppong Nkrumah, the Honorable MP for Francois Yebi, had sent a case to the Supreme Court, and then also had put in an interlocutory injunction. We heard this week that has been dismissed. because he could not meet the minimum threshold, so to say. Lawyer Powers, last week we discussed this extensively, and we said we wanted to see what will become of this case. When you heard the decision, I mean, last week you were emphatic. Your position. It looks like the court has affirmed your position.
KOJO, let me say another morning to your viewers and my colleagues and your whole team. In fact, I was not in the list taken aback when I heard the decision of the Supreme Court, because the position is that if you claim something is discriminatory, you must prove. There must be a factual basis for the claim. So it is not about sharing an opinion, because the moment you go to court, it means that you are convinced that you have evidence with which you can be able to secure success for your case. So it moves from the realm of opinion to now factual. You must now be able to prove. But if you claim that a warrant issued by the Chief Justice is discriminatory against other criminal cases, you must be able to prove. And again, you know, KOJO, we've said over here that the warrant issued by the Chief Justice did not categorically state any one particular case to be tried by the two vacation courts who are currently being criticized.
In fact, we heard that in total there were about 29 vacation courts that were given the warrant.
Exactly. You know, but because these two are already seized with these two controversial cases, that's why they are now the subject of discussion in the media. So the position of the Supreme Court, and people are saying the Supreme Court, and you see, I've read commentaries. People are saying the Supreme Court at a point acknowledged that it is a tradition in this country that vacation courts do not conduct heavy cases, so like trial. I don't think anybody has said it is not a tradition. It's a tradition. But I'm saying that even though it is a tradition, if the Chief Justice so express or exercises his powers under the Constitution and under statutes, that tradition fizzles out.
He has the right to depart on the tradition.
He has the right, because the Constitution, Article 1254, makes it clear that he is the head of the judiciary, administrative head. And we also realize that Order 79 of CI 47, particularly Order 79(1) of CI 47, makes it clear that the Chief Justice can issue warrant for a cause of matter to be heard during the vacation. That is statutory powers, giving the Chief Justice the opportunity to make decisions as to whether or not a case must be heard during the legal vacation. So even though it's a tradition, but you see, even the law itself was crafted in a manner that the law itself acknowledges that there's a tradition, but it gives room for the tradition to be what? To be breached at a point in time. So where people claim that it's been a tradition, so you cannot depart from a tradition without an explanation, but they've forgotten that there's a legal basis to depart. And if the Chief Justice does so, you cannot go or stand on top of the rooftop and be claiming that this is discriminatory. You must prove. And I was glad that he could not prove. Because if he had been able to, or he was able to prove it, of course the Supreme Court would have held for him. But he could not prove. And the thing is that the position of the law is that until you're able to have factual basis.
Okay, so let me get clarity. Now, this hearing was not for the substantive case.
That is so.
Or the substantial case. This is for the interlocutors. When you say he could not prove, what it means is he could not prove reason why the courts cannot. Because what he was asking is that on pending the hearing of his case, they should not allow the court sit.
Exactly.
And that's where the justice says that no, there's nothing that would be done that would be human right violation. So you could not establish. So that's what you mean by he could not prove.
No, the thing is that if you are seeking an injunction, there's a string of basis you must be able to establish. Grounds. First of all, that your case is not frivolous. That you have a solid case. And you must also prove that the convenience of the case, if the decision, if the injunction is granted, it will not inconvenience the other person.
Right.
Do you understand? You must be able to also prove that. And you must be able to prove that even if it inconvenience that person, damages may lie. That damages may be okay, even if the person is inconvenient. At least if the person wins and you have to pay damages, it will suffice. It will ameliorate the person's harm. You must be able to prove all these things. It is not a given that you apply for injunction and it will be given to you. You must prove these elements. So if you cross a threshold, so if you tell the court your case is not frivolous, they will look at the substantive case and say, okay, it's not frivolous. But now, when it comes to the injury, if stopping a court from doing its legitimate work, do you understand? From doing its legitimate work because of your writ, would that amount, would not be convenient for the administration of justice? So the question is, would that be convenient because of your case? So why won't allow them? And the question will be that if the court continues to hear the case, would that cause any injury? What injury would that cause? After all, the case is before the judge already. So he was not able to prove those elements. They are constituent elements, constituent grounds. If you are seeking an injunction, you must be able to prove. Now, the Supreme Court has held in one too many cases that the fact is that you must also prove that in rejecting the injunction, would that harm you, the person bringing the case to court? Is there any ground or is there any evidence that if the injunction is granted, it will inconvenience you or it will cause you injury? You must be able to prove. That is why when you look at the cases, the string of cases challenging the removal of Chief Justice, the Supreme Court rejected and dismissed all the injunction applications. Because the individuals were able to prove that if the injunction is not granted, they will be inconvenient. It will affect them. So it doesn't. So if you're able to prove, at least 2 or 3 elements, and you cannot prove that, forget it. You must prove all the constituent elements. So KOJO Oppong Nkrumah, like you were articulated, the issue of the position of the Supreme Court wasn't that it could not prove the substantive case. No, but it could not prove that he deserves an interlocutory injunction. Because you see, the court has said that stopping a constitutional body from doing their work would lead to a meltdown, a democratic meltdown. So let's say the parliament is doing its work and you tell parliament, you go to Supreme Court, that Supreme Court should give you injunction to injunct the function of parliament. That would lead to a meltdown. That is why when it comes to constitutional matters, injunction related to constitutional matters, the courts are very careful so as not to affect a constitutionally mandated body from embarking on its responsibility. So, KOJO, but you see, KOJO, this issue we've lamented and we've discussed this issue, for several days, and it's been almost getting to several months. That Ghanaians are having to discuss this issue of legal vacation. But see, let me quickly let you know that lawyers have 3 responsibilities. We call it the threefold duties. Duty to the court, duty to client, and duty to the public. So CCP. So duty to the court, duty to client, and duty to the public. And our duty to the court is primary. Where our duty to the court clashes with our duty to our client, we must resort to the court because, first of all, we are officers of the court. It is our responsibility to help the judge make the right decision. It's our responsibility. Where even the decision will affect our client, we are enjoined by the law to support the court. Which is why when you know that a particular case your client is relying on is really not a good case, you must draw the attention of the court that, my lord, this case that we cited is not a good authority. It is our responsibility, even though it will affect your client. The law enjoins us that you must be faithful to the law and to the court. So, KOJO, I have stated that, in fact, I have no respect for people who disrespect the court. I have no respect for people who disrespect the court. And with respect to our seniors, the path they took, I will not encourage anybody to take that path. Because if a court decides to hear a matter and you wish the court to defer the case, you must go to court and speak to the judge. The judge is a human being. But you can't be in the media and bastardize them and tell them that I won't go to court. It's not, I mean, that was the new law.
So KOJO did the right thing?
That was the
by
new
going
law.
to court?
KOJO did the right thing. That's why I'm talking about the others.
Okay, yeah.
I'm talking about the others.
I was confused.
No, KOJO Oppong did the right thing.
Okay.
And I've said that KOJO Oppong, what he did, it's a democratic exercise of his right.
Okay.
Because, see, ISHAQ, I have said it. Where you claim that a decision breaches Articles 23 and 296, it is not a decision for a lawyer to take. It is a decision for a court to confirm. Because any act or decision that breaches Articles 23 and 296 must be confirmed by the court. But when you sit in the comfort of your room and say the warrant issued by the Chief Justice is unreasonable and capricious, that is the politics and the optics part of it. But if you want an affirmation, go to the court. That is why KOJO Oppong Nkrumah has done the right thing.
Okay. Right.
So I support what he's doing because it gives clarity to the entire debate. But the others took a wrong path, which we must call them out so that they change. Because you see, the thing is that I have said, KOJO, and in wrapping up, that already the executive has been bastardized. Parliament has been bastardized. If we add the judiciary to the fold, that will be the end of us.
Yeah, I agree.
Thank you. We've been joined by my bearded brother, EMMANUEL. He's the Executive Director for Africa Center for Security and Counterterrorism. KOTIN.
Good morning, KOJO.
How are you doing?
God has been merciful as always.
Nice one. Nice one. So,
very good morning to Ghanaians. And with the SCG thing, I just want to have a small bite around it.
Right.
I think it's about time we depoliticize our utility services. ISHAQ is here. In the advanced countries, the private sector that are predominantly in charge. And you can see the efficiency and the competition, you understand? It looks like in our part of the world, it's monopoly. Look at ECG. This government come and bring somebody. And there's no institutional memory. At the test of any election and there's a change of government, you see change of leadership in those utility services. So whom do we blame? And the second aspect of it is maintenance culture. We don't maintain the infrastructure that will deliver these services to us. And the other aspect is wiring of our homes. Sometimes earthing, if you don't put earth wire or they don't wire your home properly, and there's some form of challenges with your wiring, you see that you buy credit and it goes. You buy credit, it goes. I understand this one exists. I understand it exists. Okay. I'm not holding brief for ECG at all. I'll be the last to do that. I'm just raising other aspects we need to look at instead of focusing on.
I've done all that.
No, that's why ISHAQ is calling for investigation.
Many, even looking at our housing infrastructure and the way we build anyhow, without regards to permit and things like that. You go to the cluster of homes where you just have homes built anyhow. You bring any electrician to do the wiring for you. And you realize that in recent times, we've been having a lot of fire incidences or home getting bent and those kind of things. Ask the fire service. Most of the time, 90% of the cost is wiring or low quality of materials you use in doing the wiring. Right. So the problems are kind of multifaceted, and we have to look at it collectively than hammering the utility services every time we experience these challenges. I think we need to provoke a debate.
So I think it goes back to what Lawyer ISHAQ said. We need to open up and investigate to see where the... But Lawyer ISHAQ, back to this legal vacation issue. Now, for the NPP, my question to you is, every lawyer's hope is to get their client to be home.
Yeah.
So if this whole arrangement is to make sure that it expedites the hearing for the people that are your party members who are being investigated, should you actually not be the ones calling for this to happen? Why are you up in arms and against it and insisting that the court should be on break and your people should still, those who are in prison should still be there waiting?
Thank you very much. Once again, good morning to colleagues, particularly good morning to him. I think when I greeted the panel members, he wasn't here. He said, brother, it's always nice to see him. But it was quite depressing about 3 days ago when I saw him doing some poor analysis of the outcome of MPP elections in the north. And then it doesn't matter. I didn't say he's not.
How did you?
I didn't say, when I get the opportunity, I'll explain it properly to him.
But not now.
So
it's going to do with this set.
No, I'm just welcoming you. And to say that it's nice to see you, yes. I mean,
he says he's missed you.
I'll come.
It's opinions.
Towards the end, give us time and I'll explain it
I'll
to
do
you.
it. He's missed you, so he just wants to show you that
I'm
he's
just
missed
welcoming you as a brother. And to say that I've been very disappointed recently as my brother.
Yes.
Yes. I agree with my friend. I think when it comes to let's look at the injunction in particular. I think when it comes to injunction, the most famous case was called the American Cinema versus Ethicon test. That is what they often use. And as you rightly said, you've already gone through some of the elements. I think the most important element that Oppong Nkrumah needed to prove was that there is serious issue to be tried. And I think that's what you meant by it's not frivolous. And then the balance of convenience is very important, where it lies, especially when money is not an adequate compensatory measure. Who would suffer the least injustice if a case is stopped? So I quite agree with you with the test. But it doesn't mean KOJO Nkrumah case was a bad case. No, I am adding that. It doesn't mean, don't be very sensitive. It doesn't mean KOJO Nkrumah
this morning
case was a bad case. I mean, if you study jurisprudence, there are so many reasons as to why a case could go the other way around. I don't know if you enjoy jurisprudence. I enjoy the subject quite well. I think Lloyd Fuller was one of the people who took a case to dramatize. Sometimes the way a judge even rules, depending on whether he's a natural lawyer, he's a positivist, he's a feminist, he's a legal realist, all those things informed. For you to even bring a case against the judiciary, and it is the judiciary, the head of the judiciary, who need to even sit on the case. I think it was quite courageous on the part of KOJO Nkrumah to bring that particular case. But having decided, I don't think that's the end of the tale. I've already heard KOJO Nkrumah said he's going to ask for a review. I'm not sure whether a review is advisable, but he said it is within his legal right. But I don't think the other lawyers who didn't go to court. You see, if you look at our article, chapter 5 and chapter 6, those fundamental rights also allow citizens to protest. Just that they have to protest respectfully. So if somebody doesn't go to court, but he's protesting respectfully, I don't think there's something wrong with that. But sometimes we often say that people who don't go to court and protest, there's something really wrong. No. As long as you are doing it respectfully. Like saying that you respect the court, you accept the decision, but you don't agree with them. There's nothing wrong with it. For me, I don't know why we often say those people are completely wrong. Because it is part of your rights to protest. And if you protest respectfully, I don't think there is a problem with it. And to your question, as to, I think you said some of my members who are, can you repeat that?
So
I think you more or less suggested they've lost their freedom.
So what I'm saying is that
yes,
for every lawyer, I've been made to understand that the lawyer's number one objective is to make their client come home or be home and be free. So if this legal vacation is going to get the courts to sit so that it speeds up the process for decisions to be taken on the free or otherwise of your members who are being tried, specifically to those two judges. Should you not be happy and even clap for it that if you want to do it 24 hours, we should do it?
Okay, so let me adopt some of it. I think I think some of the things you were analyzing was called core duties of a lawyer. I think if you do it in the English text. So I agree with you that one of the first core duties of a lawyer is duty to the court. So your duty to the court means as an officer to the court. I mean, your first ultimate goal is to allow the court to discharge its responsibility without interfering with the justice. The next core duty is duty to your client. You must act in the best interest of the client within the law. Now, acting in the best interest of your client may also mean that a case must not be rushed. I quite understand why some people say justice delayed is justice denied. But justice rushed can equally be justice denied. I don't want to see it as my party decision. This particular case is a decision of their lawyers. So I'm not sure why he said my party. But my party doesn't come in here. MPP doesn't come in here. It happens that some of them are MPP lawyers. And as you can see recent cases, it talks to you. An NDC man who is a former minister have not hired somebody who is a known MPP person as a lawyer. So for me, I see it to be the decision of their lawyers. I don't know what informed that particular decision. But if I am representing interest, and in order to be able to act in the best interest of my client, and I see that a case is being rushed, it can also undermine the best interest of my client. Why is there a need to rush a particular case? Could it be that there's likely to be shortcuts taken? And if shortcuts are taken, of which I may not have the necessary time to do proper cross-examinations, and this legal vacation, certain places will be shut down. Is it that there's likely to be documentation or certain offices, if they are left open, they might facilitate the smooth running of my case? If I realize as a lawyer that such places that are likely to be locked up or not functioning properly may delay, may not give me all the tools to be able to fight on behalf of my client, I may have to say no. This particular point may not be good for the trials. And as we have always said, this is a tradition dating back to when the British were ruling Ghana. This tradition is firmly established. It has become an institutional convention that this kind of trials were usually not going. It's a recent invention. Some people might say it doesn't start this time. It started the previous time. I remember, this is not the first time we are discussing it. I think 3 weeks ago, the young president lawyer mentioned that Kabiru case, Kabiru versus Larva case was heard during the legal vacation.
Yeah.
Yes! The cases of that nature is meant for it, certain. Because the application was a sensitive application, there was a deadline approaching.
So let me just introduce. Introduce the new Alpha.
Okay.
We've been joined by the press secretary for the office of the Attorney General, Benjamin Alpha AIDOO. Alpha.
Thank you, KOJO.
How are you doing?
Yes, I'm very fine.
Great. Okay. So yes, continue.
So there was a deadline approaching. Electoral Commission has got an application deadline, which will not wait for any political party. So if there was a pending case of which the deadline was approaching, this is a suitable case for such a period, or the liberty of the individual is at stake. This is the kind of application that have always been made. So if there is a well-established convention, and we have sensitive cases such as the Dubokini, Hanan, and Co. ongoing, if you want to breach this particular convention, you must have a good reason to breach it. And as the English always say, if it is not broken, don't fix it. If you try to fix it, this is the sort of problem we are having. And this endless debate we cannot stop. So for me, that directive was unnecessary. And my good friend here will tell you that, they didn't direct that particular case specifically. They only directed the judges who are handling the case. And the question is, what is the difference? That is a mirror inverse of the directive.
No, but the difference is that 20 plus courts have been given a warrant to hear.
Yes.
But you decide to pay attention to 2 because those 2 are the ones that are trying cases that is related to members of your party.
Yes.
So that's the difference.
It's not different. for me, these political sensitive cases, they would have critically looked at it. Because as you say, justice doesn't have to be done. It has to be seen to be done. So if a cross-section of the public, these people might say 41% of the population, if 41% of the population is frowning upon it, I think there is something, and the judiciary is already into trouble. You know that. The NDCs have made us aware that the judiciary is not independent. They are unanimous 5 or unanimous FC or whatever terminology they are using. So if people already say you are not independent and you seem to be directing certain cases to go forward, of which some people is also having suspicion, then it doesn't actually endure the confidence that my friend said we should have.
I have one simple question before I move on to KOTIN. If the warrant that was given were given to 27 courts, and these 2 that are trying these MPP-related cases, would you still have had this problem? The same agitation you are having?
I'm not really sure how to answer your particular question, but my argument had always been that convention, that trial should not go forward during that particular period.
Okay, so that's your basic principle.
For it.
Right, thank you. KOTIN.
Yes.
Your take on the matter.
Well, KOJO, thank you once again, and very good people. Good morning to the good people of Saboba and to Ghanaians in general. I want to start from where Powers ended. His statement was very powerful and telling. You see, we have succeeded in politicizing every institution in this country. And judiciary is the last institution standing. So we must do everything in our powers to safeguard the sanctity of the judiciary, KOJO. You see, discretionary powers oftentimes is difficult to impugn bias. You have elected me as the president of Ghana. You have given me some discretionary power to act. I take certain decisions and it doesn't go well for others. How do you then impugn that? That is a bias against me. What I see playing out is just political gymnastics. And if you look at the lawyers who are going to court, there is no doubt they are all politically exposed. So if you want to say that, granted, and like you said, everybody has a right to go to any court to ventilate a right if you feel that you are not satisfied with certain decisions. That's the beauty of democracy. But we must do it in a very respectful way. You don't try to paint the institution you are part and parcel of as black. You remember the famous statement the minority leader made, that the current Chief Justice was part of a scheme to remove the former Chief Justice. And Afenyo Makin is a lawyer. So, you remember court cases that were political in nature. Those, the election petition of 2012, the unanimous FC tag that was put on the Supreme Court. Have you observed a trend? If a particular party is in power, right, you don't see politically exposed lawyers from those parties going to court on frivolous applications like the one Honorable Oppong Nkrumah did, even though he has the right to do that. So this is something we have to watch. Look at the inherent right, lawyer, of a client facing criminal prosecution is what? Speedy trial. Because you put a tag on me that I'm a thief, I've stolen government money. My children are baptized in school. You put travel restrictions on me. I cannot even conduct any business because you've frozen all my accounts. In the circumstances, what is the best thing to do?
Have you heard speed kills?
What? No. Speed does, but the framers of the Constitution, what was the idea of that? And you see the dishonesty.
I heard one of the MPP lawyers, KOJO Oppong Nkrumah's lawyer, Frank Davis, criticized why Chairman Ntumi's bail application was moved to September when it could be heard in August.
Heard during the period when there's legal vacation.
Yes. So you see, you can approbate and reprobate. You see, we are sending a very kind of dangerous precedent in this country. When we succeed in politicizing our judiciary, a time will come nobody will even be interested in going to the court.
But could you?
Look at how. When an application was made, it was a serious matter, just like Kabiru and Larube's case. It was time bound. So citizens raised the question of this being disenfranchised. Was their case heard before the elections?
But
no.
the example you made with Wuntumi,
yes.
And that's what I think Lawyer ISHAQ said earlier, that in instances where it has to do with the freedom of the person, then you are allowed to be heard or to be tried or whatever it is within the vacation
but
period.
Every trial relates to the freedom of an individual.
No, this is not a trial.
Look, but let me ask this. Is it the first time that we are witnessing a situation whereby during legal vacation criminal cases are being heard?
What they are saying is
that
time. They are saying that this is the first time a trial is being heard.
No, it's not. There are precedents. Chachu's case was even one. And I remember Kwesi was even going to court every day. Look, don't let us demodernize our judiciary for political expediency, where in actual fact we know that there is nothing to even cry foul about. This is my final take on this matter. In as much as we have rights, we must exercise those rights very responsibly and know that our democracy at every stage of it should be put ahead of any other consideration. Why is it that when we are dealing with politically exposed person, when it comes to crime, we have all this kind of gymnastics? What happens to the ordinary person on the street? What are we kind of preaching? Is it that because we are privileged to be where we are, we should be treated differently from the ordinary person on the street? And more often than not, these things come up when politically exposed persons are involved. Are we really prepared to fight corruption in this country? Are we prepared?
Thank you. Alpha, now, one question one of my viewers is asking, which I'll ask is, when we say there is legal vacation, is it just an administrative break or a bars even court sitting?
Okay, thank you. Directly to answer that question, it doesn't bar court from sitting. In fact, it is as ISHAQ and others have explained, it actually evolved as a convention where, you know, we inherited the British system, you know, in 1876, and what happened was that it was the white judges, it was the colonial judges that were sitting in our court, and they used to go on vacations in the summer. This is what brought about legal vacation, that every August, September, they used to go by, they went by ship 2 weeks, coming back 2 weeks, that's 1 month, and 1 month for the stay. Right? So every year they used to go, and they developed a convention. We decided that we'll make it as part of our rules. But when we were making it as part of our rules, we also put a clawback in there, giving the authority to the Chief Justice, who administers the judiciary, to appoint vacation judges. So since time immemorial, vacation judges have been appointed to sit. And Kojo, you see, we have been at pains to explain to the Ghanaian public why this conversation and what the MPP is doing and the lawyers for the accused person is doing are simply designed to undermine public confidence in the prosecutions and as it were delay these trials. That's essentially what it is, because on every single metric, every single question that is asked about this, they fail to provide proper answer. You asked some questions to ISHAQ, and he couldn't, properly give an answer about. There was this question I remember, and then say he says, "Oh, he wouldn't know." Yes, you asked that if all the judges, all 27 judges had criminal matters before them, or would they have changed their position? He says, "Well, he doesn't know," and all of that, because the real purpose of this is to undermine public confidence. You remember that they began with the narrative that oral is dead. You remember that there were some months where they say oral is dead, nothing is happening, nobody is going to be prosecuted. Then when they realized that the Attorney General is serious, then they jolted into action and decided to move to the next gear of their strategy, which is to delay the cases and ensure that they do not receive the attention that they deserve. But KOJO, like we have explained for the past 2 weeks, nothing untoward has been done. And yesterday, that admission was made in the Supreme Court in the affidavit of the applicant himself. The question is that does the CJ have the power to issue warrants for certain judges to sit during vacation? I don't think there's a dispute around this table on that. He has the power, she has the power to do that. 2, has the CJ selected certain peculiar judges and put before them political cases? Absolutely no. The CJ has appointed about 31 judges to sit, throughout the country. In Greater Accra alone, there are about 11 of them. Some are sitting in the land court, some are sitting in probate court, some are sitting in general jurisdiction court, trying and doing all sorts of matters. So that's also out of the way. Now, is there also the convention, the practice, and the precedent that legal vacation judges have only taken interlocutory applications and never done trials? That is false. But let me backtrack a bit. You see, when you read the rules, and I hear, when I was coming, I was listening to senior powers, some reliance made on CI 47, even though properly it will not apply to criminal proceedings, right? But if we are supposed to go strictly by the enabling legislation that regulates criminal procedure, then that is the Criminal and Other Offences Procedure Act, Act 30. What does it say about adjournment? Act 30 doesn't make any provision for legal vacation. In fact, on the contrary, it says that under Section 169, adjournment must not be for more than 30 days. Does not anticipate long adjournment, and does not anticipate legal vacations. And the policy reason is very clear, and it has been articulated around this table, because the first principle of fair trial is for a person to be tried within a reasonable time. And yesterday, my Lord Justice Puaman had occasion to actually comment that means that as fast as the court resources will permit. And so when it comes to Act 30, it does not envisage long trial. The adjournment must not be for more than 30 days, even though some judges do it because maybe for some one or two reasons, maybe prosecution request time and all of that. But the rules regarding criminal trials does not allow that. Now, some reliance is even made on the civil procedure rules. And if you read the civil procedure rules and Order 79, it just says, shall appoint the judges to hear matters. That rule does not specify whether the judges must hear interlocutory matters alone or should hear trials. So now the next leg they move to is that, oh yes, it's not in the rules, but the convention is that they only hear interlocutory applications. So why is the CJ moving away from the convention? First of all, CJ has not directed anybody to go and hear interlocutory applications or trials only. Indeed, that would be ultra virus, because the CJ's administrative power is only circumscribed to appointing the judge to sit and hear the matter, and not directing the judge as to his judicial function, as to select these cases, adjourn this one, don't adjourn this one. The CJ doesn't do that, and that has not been done. And if you read the warrant, which they themselves exhibited, it was clear that I appoint you as a legal vacation judge, go sit. That's all that it says. So there is nothing like certain special cases have been put before judges. And you see,
let's take these two courts that are under contention. Kojo, it is not the case that these two courts have only oral cases pending before them. In fact, one of the courts, specialized court 1 and 2, which were in contention, which relief, I sought an interlocutory injunction against them yesterday. One is Justice Charity Assem. Before her, there is no oral case, but it's a specialized court. And I realized that they added her to the specialized court 1, for the purposes of achieving some, how do I call it, equilibrium or balance, so that they do not seem as if they are choosing and picking. But the specialized courts were created for a number of offenses: narcotics, cybercrime, galamsey, illegal mining, corruption and corruption-related offenses. These matters are before the judge, all right? So if you go to specialized court 1, where Justice Francis Achibonga sits as an additional high court judge because it's a court of appeal judge, he is trying these matters, these offenses, which we have all agreed that needs special attention, and that the state as a policy should take steps to ensure that trials or prosecutions in these matters are fast-tracked. So it is Justice Achibonga who sits and decides that today I will hear interlocutory applications, right? Or in respect of this case, I will do trial. That is what it is. That is actually what they are not happy with. Indeed, they do not challenge the Chief Justice's administrative power to appoint the judge. What they are not happy with is the judge's decision to take this case or that case. But if you are not happy with the judge's decision, the proper thing to do is either by way of appeal or by way of certiorari to get that decision or that ruling to be brought up to a higher court for the purposes of question, for same to be quashed. And so they mounted this injunction application first on wrong facts, and it has been decided, so we can talk about it. And it was on wrong facts. And my Lord Justice Poaman pointed it out that your own Exhibit E and I think Exhibit F, which you have annexed, shows that these two warrants does not select any special cases, but your plaint is that you are challenging the Chief Justice's selection of certain special cases to be tried. All right? And even what made the matter even worse was, I think, Exhibit F, one of the exhibits which exhibited the full roster of vacation judges, for the judge to see that, oh, indeed, it is not just these judges that have been selected, but there are judges that have been selected nationwide, in keeping with the tradition of legal vacation to hear matters. So, Kojo, the totality of the issues is that they intend to delay these trials. And Senior KOTIN raised a very important governance issue, which I have highlighted in the conversation throughout the past 2 weeks. That, you see, we are in a country where citizens have decried the slow pace at which the political class, as the minority leader calls them, the political class are tried and are held to account. We see political people being put on prosecution and the cases delay forever. And that weakens the confidence in the fight against corruption. So the people say that if I, ordinary person, Kojo, you go and, God forbid, steal a mobile phone, you will be put before the court, you will be tried, you won't have a political judge to go and raise an issue that your case should never be heard during legal vacation, and you will be convicted and sentenced.
A political lawyer.
Sorry, a political lawyer to raise that issue, sorry. You will be convicted and sentenced. Why should it be that when it comes to people accused of corruption, we cannot have these trials go on?
Right.
Even if that is the purpose of which the judges decide. And let me learn. The judges decide. And the more important question is that I cannot for the life of me understand why, if a criminal accusation is on me, I will not be in a hurry to go to the court to clear my name and have my life. Because a criminal accusation in itself, even though you're on bail, impairs your liberty to a certain extent. Because part of the bail conditions for a lot of the people is that your passport will be deposited at the court registry, is that you will be placed on the stop list, that you have to report every now and then to the investigative bodies.
And your account is frozen.
Yes, your account is. Why won't I be in a hurry to go to court to go and clear my name when the Constitution actually says that I should be tried within a reasonable time? It is all of these pieces of information that point any objective observer to conclude that this is meant to delay, because if you interrogate it on any front, their case fails, and it is just intended to undermine these oral prosecutions and delay. But you know what, Kojo? The Ghanaian people are with the government on this. You should check the temperature, the sentiment of people when it comes to the prosecution of this case. In fact, on 7 December 2024, the Ghanaian people made a certain commitment by voting for Operation Recover All Loot for the NDC government to use the powers of the state to root out systemic corruption, bring accountability to public office, and as much as possible, punish persons who are found by the court to have engaged in any wrongdoing or public plunder of state resources. So the Ghanaian people are with us. And we are confident that these cases will move and conclude in good time.
So I would also want to introduce another panel member who's joined, KWAME OWUSU DANSO lawyer. He's Executive Director for Lands and Mines Watch Ghana and also a private legal practitioner. KWAME. Good morning.
Good morning to you.
How have you been?
I've been healthy.
You know why I'm asking you, how have you been? Right, anyways, I'll give you a time to breathe. I'll come back to you. So, powers to the end. I need to move to another, so I'll just take 2 minutes from each of you, then I'll move. So what's the way forward now? Powers.
The judges must do what they have been tasked to do. And I have said that nobody can stop Justice Achibonga and the others from embarking on their legitimate. They've taken a judicial oath to dispense justice to all manner of persons. So if you feel when you are alleging discrimination, you must be able to prove. And we leave that to Oppong Nkrumah and his lawyers to prove that, particularly when the substantive matter is heard appropriately. But with the interlocutory injunction, obviously, looking at the manner in which his case was framed, there was no indication that he would have been able to succeed in getting an injunction. I was convinced in my mind that this thing will not fly. Because if you are minded about the jurisprudence of this country, particularly when it comes to injunction in constitutional matters, you know that this case that Oppong Nkrumah filed, particularly the interlocutory injunction application, will not succeed. And Kojo, let me put on record. The thing is that there were avenues open to the two lawyers, the two senior lawyers. I mean, my respected seniors, Atachia and Godfrey Dame, to have explored in resolving their matter. One of such avenues should have been to meet the prosecution to agree. I mean, they would have been amenable. And again, the GBA, let me put on record that the statement issued by the GBA does not represent me. I read the statement, I felt I was not represented in the statement. So the GBA leadership wrote their own statement.
Politics have taken
they wrote their own statement. And their statement, even though I'm a member in good standing, that statement does not represent me. And I dissociate myself from that GBA statement.
So now there's GBA, there's GLS.
The GLS, that's what them, their conversation is a different thing. And I thought the GBA could have done the best, could have done better. Because when these two individuals complain to you, you being the mother organization, what should you have done? Walk into the Chief Justice's office, meet with the Chief Justice, and resolve the matter. But you also join them to bastardize the judiciary in the media. And their first resort was to issue a statement in support of the others.
Maybe they had done the backroom discussion.
They have not done that. If they had done that, they would have told us. Because this is not the first time people have had issues with either an action of the judiciary. That they've taken the pains to go and meet the Chief Justice. There have been a number of cases where lawyers, senior lawyers, have gone to meet with the Chief Justice to address or raise those issues, those matters with them. And the Chief Justices in the past have taken steps to address them. So there was nothing stopping the GBA from approaching the Chief Justice to resolve the matter other than going to the media. In fact, like I said, the GBA statement does not represent me. I dissociate myself from that GBA statement. And I want to point on record that the two others took a wrong path. And I'm ashamed that they took this path. Because young lawyers should not be learning from such examples.
Right. Lawyer ISHAQ, you've made it clear that you are not in support of this whole legal vacation. And I think last week you even said that the people who brought it have even stopped doing it.
No, that wasn't me.
Oh,
I actually said it's good.
Oh, okay.
I actually defended it.
Defended the legal
vacation?
Okay.
Yes.
As what you're against is having whichever form of
trial during the legal vacation. But I actually defended it. I say in England, in fact, contrary to what Alfred said, Alfred made it to seem like they were doing it because they have to travel back. That's not correct. The legal vacation is firmly established in England. In fact, I actually said last week that during the legal vacation, they actually use it not just to rest, but education.
Yes.
As Lincoln Inn, you remember I said the right to be forgotten laws. Yes, I've even received an email from Lincoln, the right to be forgotten laws. Judges and students and senior lawyers will debate it. So it's contrary to that. So it's not just because they were traveling back. But it's maybe. Yes.
The colonies had to go back. It's the same thing.
But the way you're saying it was because the break was there because they have to go back.
No, that's a history from here, from Ghana.
That is it. There has always been legal vacation in the English system, and the judges in the colonies just have to go back to be part. And we are not saying there's different things.
The primary reason is for them to abreast themselves with new precedents and some of the cases
from Ghana.
Okay.
You are saying it from the.
It's not. We are not saying different things at all.
So to get familiar with the new cases and new legal decision emerging. But I've listened to Browers Powell. I don't think the GBA was completely wrong. In fact, you said they bastardized the judiciary. I don't think if you read the letter, they were not attacking the judiciary. But what I want to say is the case have gone to court. The court have more or less made a decision. If there's no review and the case, the decision stands, it means that it has set a new precedent. There will be nothing special anymore. But if it is established, let the other side know that they should not switch sides when the coin turns. I feel Markin tried to say this, and they said Afino Markin was threatening them. Just as they are asking people to bring 70 million, 50 million before they are able to secure a bail. It is a new precedent I have said. So for me, the way we do things here, we are damaging the system. Right. Because future court would try certain cases, the very people who are defending them now will be the very people, because not long ago, our memory have not gone long. Right. When the case went to court about the composition of parliament, who has the right to decide whether members are gone or not, we saw what happened. The very people who pretend to be the friends of the judiciary today, they were the very people who were attacking the judiciary viciously, to the extent that it reflected in the Afrobarometer report. So let it be very clear that the NDC as a party is not a friend to the judiciary. No. They only say, they only go to the side of the judiciary where it favors them.
Right. Okay. Yeah. So, KOTIN, last week I asked a question and I'll ask the same question. Across the length and breadth of every institution, people go on leave at their own timing. Yes. Now, we've been given the history why this legal vacation was necessary then. Times have evolved. Technology has come in. Things have changed. Should we depart from that and let judges plan their leave and go as and when they desire, not have all of them take? Should that not be a way forward to put all this at rest?
You see, KOJO, the law was meant for people. And that's why over time we review laws to meet the needs of our time. I don't think there's anything wrong with that. If we have a national consensus with our stakeholders, and we all agree that it's not helping our current needs. That's the beauty of democracy. And what my good friend Lawyer ISHAQ said on the bail conditions, I think it's something we have to look at. I agree completely with him. We have to show human face when it comes to bail conditions. Because the mantra of you are innocent until proven guilty still holds. So it doesn't mean that if someone is accused of corruption, the person is guilty as charged. You then have to go to court and what? And then prove same. The other thing I want to raise is about governance and freedoms of clients vis-a-vis lawyers. And I was happy Lawyer Powers mentioned the CCP, the role of lawyers to their client, to the court, and to the public. You see, Chamaun to me is still in jail, probably because of the actions of his lawyers. If all the processes that led to the brouhaha we are talking about was not invoked and probably the lawyers were in court so that that application be moved, there was 50% or even 60% chances that he could be granted bail pending the trial, given the role to me is playing in terms of businesses he has and people he has employed. So who is to blame? Do you blame Wontumi? Do you blame the state? You blame the lawyers. Now, the Ghana Bar Association, honestly, I thought they were no longer in existence. I don't remember the last time I heard about the Ghana Bar Association issuing any statement in the last 8 years. You remember a matter of constitutional importance, SAO, when they were disenfranchised. Ghana Bar Association lost voice to even talk about it. So I'm just pleading with Ghanaians, because I'm coming from the governance perspective. I'm not a lawyer, you understand? Is it possible that the judiciary can have an open consultation with all stakeholders to put all these allegations to rest? Then we have a fresh start. Because that is the only institution standing that could check our fledgling democracy. Because when we have issues with our presidential elections, who was the final arbiter? Is it not the judiciary? So if we demonize it and make the public to lose confidence in such an institution, what do you think we'll be doing to our democracy?
So just a bit of correction. Yes, yeah. Within the 8-year period of the NPP, there were some. In fact, there were a lot of statements issued by the Ghana Bar Association. There was the one on the judicial independence and the rule of law, the elections and electoral processes. I
cited a specific example of constitutional distance.
But even the references is making.
What is the position?
What's the position of the GB?
What was their position? They were supporting it.
You are mentioning topics, not the position.
The unanimous FC conversation started. So it's not even in support of positive, conversation.
At all.
Right. So he's right.
Okay. Alpha.
Yeah. Okay, so yeah, for me, a few matters that Senior ISHAQ raised, that the NDC has criticized the judiciary in the past, and so they cannot pretend to be friends of the judiciary now. Look, I think that the judiciary themselves know that they are not above criticism. So the issue is not about disagreeing with a decision of a judge or disagreeing with a ruling of a court. We are all entitled to do that. I'm sure Senior ISHAQ disagrees with the Supreme Court's decision from yesterday. He's entitled to do that.
I don't call it unanimous FC.
He's entitled to do that. It is when we try to go beyond what is legitimate criticism to run down the court based on factual misrepresentations that we actually attack a very critical institution of democracy, the last bastion of democracy. All right? So let's distinguish, legitimate criticism of the judiciary from ones that have the tendency to run down the administration of justice and all of that. And then also the fact that, when the tables turn, as he sought to portray, we shouldn't change our position. Well, the tables have actually turned now. Atto Forsen and Co. went through trial. In fact, Atufuase's trial was scheduled to go on during legal vacation. He was only saved by the Court of Appeal on the last day of the legal year. Ifiasa Riboche scheduled a trial for 1st and 2nd August. These are legal vacation days. But before that, he had done a submission of no case which had been dismissed by the High Court, and he had appealed to the Court of Appeal. And the Court of Appeal on 31st July 2024, acquitted and discharged him, upheld that submission of no case.
So did you hear that? He was saved from trial on legal vacation. He was saved.
But
meaning there's something negative there.
He doesn't understand the principle. The principle is that he was scheduled to be tried during legal vacation, and I can show it to you.
And so he was saved from it.
Yes, because he did a court. A submission of no.
And yeah, he was saved from it.
No, I'm saying that he was saved from that trial by the Court of Appeal. The Court of Appeal upholding his case. Otherwise, it would have been so that the argument that there have never been trials during legal vacation is what I'm trying to disprove. Also, we remember the quality grain case, all right? That involved the finance minister under President Rawlings and our Greek minister under President Rawlings. Okay, Kwame Prepra and then Ibrahim Adam. They were tried during legal vacation. They were accused in respect of a rice project at Aveime. It became known as a, yes. There was, if you check the court record, 13th August 2001, they tried them. In fact, on the a very interesting thing is that the prosecution had even asked for long adjournment. Justice Kwame Afre said, no, bring them on 13th August, bring all your witnesses for us to hold trials. There were recent parliamentary election primaries that elected this parliament, okay? What happened in the MPP in 2023? The election that happened in Wale, it was between Dr. Tia Kabiru Mahama, who is now in parliament, and the former gender minister. I think her name was Lariba. All right?
I thought we have already spoken to it. Maybe you have to speak to the nature of the decision.
No.
The point, it was time-sensitive application.
Yes, but the point is that it was, you see, there's a difference between whether the thing happened and the reason for it. We can always argue about the reason. But if your point is that it has never happened.
No, what we say is that legal vacation is for applications such as that.
I'm saying that it wasn't an application. There was a full trial.
Yes, because the deadline was approaching.
Now he says it was only application.
And the electoral commission.
No,
don't mislead the public.
Now
you left the South case out. Misleading the public.
No, you are actually confused. You said it was an application. Then now you say, oh, the timeline was approaching. Was it an application or a trial? KOJO, it was a full trial. It was a full trial between the defendant, whose lawyer was Senior Samson Ladianini, all right? And the plaintiff whose lawyer was Senior Sylvester Isang. He himself, he's an MPP man. He's actually gunning for the Nandom seat. He himself said that the judge informed them that he had obtained a warrant to try the case during legal vacation. I can give you the extra. So it was tried. We can always look at the reason, whether there was time limit or, but I'm disproving the point that there have never been trials during legal vacation. That's it. We can argue about the reasons.
I think that one is established.
So
there have been trials.
There have been trials. Please, there have been. The fact that, there have been a lot of, the convention has been a lot of interlocutory applications doesn't mean that there has never been trials. And I have pointed this out to you. And so if a judge takes a judicial decision that to use my time during this period, I will hold trial. Remember that when the vacation judge, the judges that have gone on vacation come back, these vacation judges are also going on vacation. They are also going for 2 months, which effectively eats into October and November. When we come, there's another break in December. It means that the next time you can hear his cases in January. So he's using the time effectively. And that's why Chibonga continues to insist that once he has been given a warrant, he will sit unless the warrant is revoked. And he would administer justice. He will see to the conduct of his cases. All right? And there is nothing untoward about that, both in law and in convention.
Thank you. So we would want to announce our WhatsApp numbers 053-110-1315, 053-110-1315. Before we take our break, we would let lawyer KWAME also speak to the issue before we take a break. We have a break. So now I'm giving you the time from now to my break time.
What time?
That's about 7 minutes.
10 minutes.
That would do. I'm sure I'll just need about 2 minutes.
You say you take 2.
Let me say a special.
Let's agree.
Let me say a special good morning to Justice BRAKO-POWERS.
Justice.
No, maybe you become a judge. Small boy danger, shattering every conversation. No. If I say you don't, he understands what I mean by small boy danger.
Papa knows I don't want to be on the
Okay.
He doesn't want to face what you are facing. He doesn't want Afenyo to come after him.
I'm telling you.
And see the ISHAQ, KOTIN, and my brother Alpha. Then KOJO, to yourself. I've been absent from this show for very important reasons. I was involved in a very gory accident. Very gory accident, and I came out unscathed. So when people see me, they think that really? Fortunately, I was using my Land Cruiser, so it somersaulted, but I was able to. I wanted to do the old man a great honor, and myself, by going to put a flower on his grave, on his tomb, and unfortunately, I didn't even get to my destination, and it happened. But everything happens for a reason. So I just, I want to apologize to the viewers for absenting myself from the show for some time. It was due to very serious circumstances. Having said that, let me also indicate that I was listening to my brothers on my way here, and so I listened to the varied arguments expressed, very profoundly so, depending on whether or not it supports the argument of the minority or that it supports the argument of government. I think that they have very profoundly distinguished their analysis, and I'm very, very happy about it. Today, it was not one of personal attacks, it was one of dissecting the issues, picking them one after the other and explaining their positions. And I listened particularly to BRAKO-POWERS, how erudite, and how eloquent he was in explaining his matters. And also KOTIN, But KOTIN said something in the second round. He said, I'm not a lawyer. Who says all lawyers are intelligent? Afenyo Market is a lawyer.
What are you saying?
Afenyo Market is a lawyer. One of the first things I was told when I got the opportunity to go to Makola, when I was being interviewed, I did post call. So post call, they interview you. At the time, Nana, the director, went on my Facebook and I seen a post I had written about Nana Danko Akufo-Addo in a very disparaging manner. Then he says, Kwame, I can understand you may have a political ideology or views, but in this practice, it's regimented. You respect your seniors. And so under no circumstance must you write negative things or must you be condescending in a manner that will create a certain disrespect, for your seniors. And so I am just advising you. I'm not saying that you cannot write what you think, but just, and since then, if you check my Facebook, since then, I never wrote anything negative about President Akufo-Addo. I just wrote my opinions and I stated them as forcefully as I could, but devoid of any insult or any personal attacks, etc. I'm saying this to mean that for lawyers, we are seen as people who are supposed to have certain level of respect. And in all matters of national conversation, it is telling, that even by the way we speak, etc., we must exude a certain level of decorum, right? Even in our conversations. And so, if you have people who are supposed to be seniors or who are known to be seniors, make or advance arguments, which arguments does not support the practice, it is quite surprising. That you have Afenyo Markin who has appeared before judges, who in the past I could even describe him as the aide-de-camp to some of the judges. Now, because he's sitting on the other aisle, make the point that a sitting chief justice, listen to him, a sitting chief justice was part of a grand conspiracy to remove another chief justice. I mean, if this is not foolish, I don't know what best can be described as foolish. Ghana Bar Association hasn't spoken. KOJO, KOTIN and my brother Powers made some statements, and I want to regurgitate. They said that we have 3 institutions. Undoubtedly, the 2 institutions have been bastardized because of the extreme partisanship that we have displayed over the period. The last organ that all of us, would want to ensure that there's some level of sanity, right, prevailing within that organ, is the judiciary. And so if we are not able to jealously protect and guard the judiciary and to ensure that whatever it is that they do, right, of course, like my brother said, they are not above reproach, but we must not deliberately go on an agenda simply because of our political expediency to bastardize the institution. Then where are we headed? Already our democracy is fragile, and let nobody think that our democracy is built on solid rock. Our democracy is very fragile. Look, there are some quiet, in my view, issues that are coming up. Ethnicity, I don't know if you've noticed. Tribalism, I don't know if you've noticed. Religion. You see? So all of these things, right, if we are not careful, we'll pick democracy apart and we'll be left with nothing. So I've always consistently maintained that you can do your politics, but as much as possible, eschew extremist positions from the practice of politics. Because what is politics? Politics is about ensuring the survival of democracy. And that democracy is what will give you and I the opportunity to come and sit on TV and lament. Now, Afenyomakin is, in my view, not fit for the position that he's occupying. Afenyomakin is not fit to be the minority leader. Because you see, when you occupy a certain office, it comes with a certain, it must come with a certain aura. You must give a certain impression about, how possibly intelligent you are, how you are able to hold your own, but holding your own in a very respectful manner.
Right.
That office must be treated with utmost respect, with the greatest of respect. Afenyomakin is not representing that office very well.
Okay.
Office which has been occupied by,
so I've allowed you to do your own reflection this morning.
You did
no, okay. You've done the reflection.
Chairman Sabosu, etc. They have occupied this position in the past, and you can tell how serious they were in discussing matters of national relevance.
Okay.
In concluding, Kojo, I want to congratulate Kojo Oppong Nkrumah, because this is what democracy should be about. That if you have a view which is incompatible with what is prevailing, the avenue for expressing same is the court. It's the court. And respecting the court's opinion is also part of the process. That your view may be incompatible with what is currently in operation, right? You go to court, the court says, no, your view, which is incompatible, yes, you can hold that view, but the position of the law is this, or the practice is this. And respecting the outcomes of it is also part of the process. So I want to congratulate him for going to court. And for even all of us seated here as lawyers, because we were all confused as to whether or not cases can be heard during legal vacation or not. Now the matter has been settled. And so I am happy that he actually took that very bold initiative to go to court. Now the matter is settled. Now all of us have become alive to the fact that during legal vacation, cases must go on.
Thank you.
And the thing is also that, and I'm ending on this one, what is it that we want, right? At one point, if your client is languishing in cells, for instance, if let's assume that Wuntumi had not been jailed and he was in police custody, okay, would they have said that because of legal vacation, the court must not sit to hear his bail application? You see, let's not do this. Your duty is to the court, and I think they've stated that, but your other duty is also to your client. Expeditious trial does not, sometimes when I hear this, I cringe. The fact that there's an expedition in the trial does not mean that we are yes, it doesn't mean that. Because you see, in court, the rule of the game is evidence. And if you claim that you have a solid rock matter, does it matter whether the trial is being expedited?
Right.
No.
Okay.
You get the point. So I believe that all of these matters really have been put to rest, and I'm happy with the outcome of the decision of the court.
The rule of the game is evidence. When we come back from the break, we'll be looking at the evidence that is available to support whether 22 billion has been lost or okay. Anyway, has been lost or not. For those of you listening on radio, like I said, the WhatsApp numbers 053-110-1315, 053-110-1315. Please send your comments, send your remarks. If you have questions, you can mention that, you can send them. We'll do well to ask our panel members to respond. When we come back, we'll be discussing Goldbod, BOG, Afenyo Market. We'll be right back after this break.
From the heart of Africa we stand, building dreams across the land. Every step we at your side, helping you rise, taking you higher.
Strong as a group, close as a partner. Bank of Africa lifting you higher. African Bank with global reach. BOA make your future glow. Strong as a group, close as a partner. Bank of Africa lifting you higher. African Bank with global reach. BOA make your future glow. BOA, we go there for you night and day. Strong as a group, close as a partner. Bank of Africa lifting you higher.
Bank of Africa, as strong as a group, as close as a partner.
Stay back and stay safe. The National Petroleum Authority is cautioning the public to desist from scooping or fetching fuel from overturned fuel tankers at accident scenes. Do not get closer to the scene in an attempt to take videos or pictures. Inhaling the petroleum product is detrimental to your health. Worst of all, petroleum products are volatile and highly flammable, and a small spark can trigger a catastrophic explosion, causing deaths and loss of property. Call the Ghana Fire Service or Ghana Police personnel to handle the scene, or reach the National Petroleum Authority's contact center on 0302 550 380. Your life is worth more than a gallon of fuel. This Save a Life campaign is from the National Petroleum Authority.
Afenyo Markin and his followers have consciously chosen to disregard the Auditor General's confirmation that Goldbod did not record an operational loss. They now claim that the Auditor General did not have access to the full picture concerning the operations of the Goldbod. This position, ladies and gentlemen, betrays either a crass lack of understanding of how an external audit is conducted, or a deliberate determination to undermine yet another independent state institution, independent constitutional body, when its findings do not suit their mischievous narratives. I invite you, the media, you who are the fourth estate of the realm, to check the veracity of this claim with the Auditor General, and you will come to the conclusion that officials of the Auditor General were given unhindered access to all relevant information in the conduct of their audit of the 2025 financials of the Ghana Goldbod. All documents requested by them were supplied, and all queries raised by them in their management letter were satisfactorily answered. This is why not a single, and I repeat, not a single adverse audit finding was made by the Auditor General in its 2025 audited report on the Goldbod, not on imaginary or hallucinatory losses, not on procurement breaches or breaches of the Public Financial Management Act. Not a single adverse finding was made against the Goldbod in the report of the Auditor General on our accounts for the year 2025.
Okay, welcome back from the break. Current agenda proudly sponsored by Bank of Africa and the NPA. The major question is our 22 billion cedis lost or not? If it is, where did it go? If it's not, then what is all this about? I'll start with Lawyer ISHAQ. What exactly is this 22 billion loss being alleged by Honorable Afenyamak and by extension the minority which represents the MPP? What is the issue?
I think the minority is very clear. First of all, I think we must commend the minority. They are doing a very, very good job. You see, the NDC seem to think the moment you win an election, you've attained the right to govern and everybody must shut up. But they've forgotten that the minority are equally given a responsibility by the good people of Ghana to hold the majority account of how they are using our public funds. So whenever you accept a democracy, you have to accept both sides. Some people would have acquired the right to govern, and some people also acquire the right to hold those who are governors to account. That's the role of the minority, and I think they are discharging it quite well. And among them, they have taken a report issued by the IMF, of which the NDCs, when they are in opposition, the IMF seems to be a very reliable source. But when they come into government, the reliable source they always rely on when they are in opposition becomes an unreliable source. So the IMF have highlighted some of the losses in the Bank of Ghana. And when you follow a proper rules of attribution, those losses can be attributed to the Goldbod. But Goldbod is telling the good people of Ghana they have earned surpluses, they are doing very well. But if you trace it properly, Goldbod is engaging in creative accounting here. It's pure creative accounting.
How so?
You send bad news to somewhere else. In this case, it's the Bank of Ghana, of where it is recorded. And then you send the good news to Goldbod. So it's very clear. And in fact, some people said the 22 billion the minority is alleging, it's even less. That is, we have even bad news. If you had the withholding tax that was abolished by the government, that if you add it, the losses are actually bigger. So for me, regardless of what they call it, Goldbod can deny all that they want to deny. But there's still a loss. They cannot deny that there was no loss. And I think the main point they are denying now is that they admit there is a loss, but the loss is attributed to Bank of Ghana. But we believe it's properly attributed to Goldbod. So I don't think the minority is wrong.
So let's do a genuine walk.
Okay.
Okay. Now, the central bank wants to have some gold in its reserve. Now, the central bank, by virtue of its objective when it was being set up, cannot go to the market to buy gold.
Okay.
So the central bank is looks for an institution which has the mandate to buy gold.
Let's say an agent. That will be clearer to me.
So get an agent to buy gold.
Okay.
Your own words.
Yes.
Okay.
So once we have used agent, so we are going on that. So get an agent to go out there to buy gold. The central bank gives the agent what price to buy the gold. The central bank sets up the fees that the agent is supposed to pay. And all those things.
Okay.
So the central bank now gives the agent this money. The agent goes to buy the gold, brings it back to the central bank, takes his operational cost or its operational cost and everything from the money that was given, because I'm going to work, I have to do whatever it is, and I bring the money to you. Now you go to do the trading. And what we are discussing here is a trading loss.
It's a
trading loss is one of the losses you can have on a P&L loss statement. Okay. So this is a trading loss. Basically what means that it is a loss that is made as a result of, it can be as a result of exchange rate differentials and all that.
Yes.
So now it comes back to the central bank, and at the point when it comes to the central bank, there are probably changes in the exchange rate, and so for that reason, there is some loss.
Yes.
Why are you blaming the agency who was just given the job to
He's
go and buy
a terrible agent. It's a terrible, terrible, terrible agent.
How?
You can blame the agent, just as, for example, as you've analyzed them. If the central bank were to be had made a good profit, are you saying the agent wouldn't have taken some of the?
I don't expect them to.
Of course they would. They would exhibit themselves as a good agent. We bought it for them. They would. They will use it as part of marketing them. But I'm not really sure the way you are reporting is clearly the way it is.
It is.
But nevertheless, even if that is, if that is the case, this agent would have presented themselves as one of the best agents. Yes. For me, the laws can be attributed to them. And let's even take a step back. He has had the opportunity to speak to the good people of Ghana. I mean, if you look at his manner of presentation and everything, was he really speaking to the good people of Ghana with respect?
For the statement that he came to read, yes, he was.
Was more or less discharging his constitutional duty of holding them to account. He himself admitted they have given him large sums of public
including
funds.
the comment that somebody's bail condition might be. That was also part of his constitutional duty.
I think you remember last week I told you this is a flowery parliamentary language. This is how they speak in parliament. Go to parliament and listen to them. He was putting it in flowery language, and it is not today we are all mentioning it. Even today we said it. He is talking to the totality of the system they have put in place. If a current court is asking people to bring 70 million to secure bail, let's assume what he's doing, there's really something wrong. The future government might ask him to bring more. We've already said it. Because a precedent would have been set by the way the courts are currently asking for it. And I think if you switch on the cameras, behind the scene, the NDC, some of them are not happy with the bail conditions. So if somebody is reminding him that, okay, if you continue in this trend and the kind of bail conditions they are asking people for, with these sums of money given to you, because all the bail condition, sometimes we are told here is that the bail condition is linked to the amount of money involved. And how much did he say was given to him in cash? I think billions, isn't it? Yes. If billions are given to you in cash, and one day they say you have caused financial loss in the state, and if they are linking bail condition to the amount of money involved, of course his bail condition will be higher. I mean, what is wrong with saying that? We have been saying it here, that if you do that, you are setting wrong precedents. But the point I was making is
advocated against excessive bail conditions.
Yes, I've advocated it. But what I was saying is that no, I am not justifying it. I am saying he's saying reality.
And the money is
no. There's difference between justification and explaining what somebody said it means. I am not validating whatever Efenyomake is saying. But I am saying is that Efenyomake is saying the realities to what is happening now. That if they are linking bail conditions to the sums of money involved, and the current money that he said he has collected to go to the market to buy, if it is alleged that he has got financial loss in the state, the reality is that the bail condition will be higher. So I wasn't justifying it. I believe bail condition, we need to look at it critically as both parties, as Ghanaians, because you and me could be affected one day. But the point I want to say before the interruption is the way and manner in which he has spoken to the good people of Ghana. He wasn't just speaking to Efenyomake, because Efenyomake is just a small subset of the people of Ghana. He is a public servant. He needed to speak to us with respect. And I'm happy that his own party, Nilate Vanderpoy, I've listened to him in the City News.
He's issued a statement.
He even found a need. Of course, there's pressure from the back. I mean, he has a political interest. The first thought is what is correct. His first thought is that the guy is wrong. He even found the need to apologize on his behalf. Of course, when he go home, there will be pressure on him to come back to retract it. So don't worry about the second statement. Believe the first statement. The first thought is what is correct. Right. He did not speak to the good people of Ghana with respect. In fact, as I've already said, the opposition has a constitutional role to play. And if it's playing it, you can find an appropriate time to have your issue with him. But when you are explaining to the good people of Ghana how bad you have discharged your stewardship or your agency relationship with Bank of Ghana, you need to explain to us with respect, not contempt, as he has already displayed.
Right. Thank you. Now, Alpha, in 2023, there were some losses.
Yeah.
Then your party, the NDC, was in power.
Yeah.
And the mantra was...
NDC was not in power.
Sorry, it was in opposition. Yes. Sorry. The mantra was, who sells gold and makes losses? 2024, that was the same mantra.
Yeah.
Now, in 2025, we are now hearing that the trading losses that were made was actually an exponential increase of what had been done in 2023 and 2024. Are they not fair in calling you that if you say you came for a reset, why are you even growing in depth what we were doing that you thought was wrong?
Yeah. KOJO, so thank you. You see, this matter, the best way to introduce it is what the CEO of Goldbod, Mr. Sammy Gyamfi, said, that it appears to be a tactic designed for constant repetition of a fiction for it to become fact. You know, I don't know if you know of Joseph Goebbels. Joseph Goebbels was a propaganda person hired by the Nazi party during the German war. That was what he believed in, that if we put out a falsehood, once you hammer it consistently, it will sink in the heads of the people and that it will transform to truth. That is exactly what is being done. Could you now to specifically your question?
You know why I'm laughing?
Yes.
Because the MPP are saying that you were the masters of that.
No. And I'm coming to answer directly your question.
Right.
In 2023, when these losses were announced, it was losses of the Bank of Ghana. It was losses of the Bank of Ghana. Did you hear anybody say PMMC? Because PMMC is the predecessor company to Goldbod. I hope yes. we are all on one page on that. It was the Bank of Ghana. And the real question that was asked at the time was that what did we benefit in terms of economic dividends from these costs or these losses? Remember that it was at the time that we had hyperinflation of about 54%. Our gross international reserves were just about $11 billion. Okay? All the macroeconomic indicators were plummeting. So the right question is that if the Bank of Ghana had put in this amount and we are still not getting the benefit, because this amount is supposed to lead to some reprieve for Ghanaians in terms of economic stability so that ordinary Ghanaians can enjoy from it, then what exactly did the MPP do with the Bank of Ghana losses at the time? So that's a direct answer to your question. Now, let's come back to the issue. You see, you gave a very brilliant introduction when you were trying to summarize the model under which this whole transaction has occurred. Look, I think that the discussion has been obfuscated by technical jargons. And the population now that we have, the Gen Z population, need to understand this. Most of them seem to be lost, and if we don't take care, they will not understand. All right? And so your summary was very perfect. It is a very simple matter. The Bank of Ghana, under its mandate under Article 183, ensures stability of currency and is designed to spur economic growth. Now, there's a policy choice as to what you do with the Bank of Ghana. Okay? Under the MPP, and this is a very important point, that these losses, so-called losses that we are discussing, which anyway is never attributable to Goldbod, and you can ask ISHAQ to point you to where in the IMF report that they said Goldbod has incurred those losses. And I'll go and read the controversial page 8.13. But in the report, the IMF raised 16 lessons. And this is not a profit and loss report or an income statement or an audited. It is just one IMF staff called Guillaume Nolin said that looking at how Ghana has operated the domestic gold purchase program, they need to evaluate it and then come up with certain lessons. That's what it is. But let me come back to the background. So the Bank of Ghana decided that at that time where our economy was under distress, they will come up with a policy where we will be able to gain foreign exchange to strengthen our cedi and also strengthen our reserves. So what did they do? They said that, okay, they will appoint an agent. So that the agent goes out there. And KOJO, your explanation was brilliant. To go and aggregate and mobilize gold for them so that they, the Bank of Ghana, will sell to off-takers and then bring in the forex to help, shore up our economy. That was the policy design of the domestic gold purchase program, which was designed in 2021. Now, PMMC was that agent that was doing the aggregation. Okay, so when Goldbod took over, you remember that they took over from PMMC and they have now transitioned into Goldbod with a more enhanced mandate, okay, under the Goldbod Act 1140. All right, so 2025 was a transitional year. What that means is that whatever arrangement that existed in terms of agreement that PMMC had signed with the BOG and all its partners in this arrangement still persisted. But the difference here is that, and it's acknowledged in the IMF paper, is that this one was expanded to meet Goldbod's new mandate. But don't forget that the policy design was still the NPP policy design of domestic gold purchase program. In fact, the Goldbod Act only came into force in April 2025. And the Goldbod even received their first revolving seed capital to begin operation in December 2025. It was in March 2026 this year that the real Goldbod model, as envisaged under the Act, started operating. And no, auditing or financial statement has come because we've not ended the year. So what we are talking about is the transitional arrangement from PMMC to Goldbod within the year 2025, where these losses are deemed to have occurred. Now let's scale it down and take the issues one by one. First of all, if we are looking for profit and loss, financial statements, audit statements of any state institution, where do we go to? Which agency is the institution responsible for that? It is the Auditor General, and Article 187. Article 187 says there shall be an Auditor General in Ghana whose office shall be a public office to the public accounts of Ghana and all public offices, including the court, the central and local government administration of the university and public institutions of like nature, of any public corporation, which PMMC Goldbod is one, organization established by an act of parliament, shall be audited and reported on by the Auditor General. Pursuant to this, the Auditor General audited PMMC Goldbod, I've told you it's a transition arrangement, and found them squeaky clean. In fact, it is indicated in that report that they actually made surplus. Okay? Now, let's come to those attributed loss. And let's go to the third page 8, and I'll read that part to you.
I can read it for you.
Yes, please read that part.
So DGPP operations have generated significant losses for the BOG.
For the BOG, okay.
Losses in 2024 were equivalent to almost $400 million. That is 0.5% of GDP.
Okay, under the MPP.
1/3 of which were related to gold for oil.
Okay,
G4O.
That's their program.
In 2025, the significant scaling up of DGBP operations led to losses of over $1.7 billion. Almost 1.5% of GDP.
No mention of Goldbod yet.
Almost entirely relating to gold for reserve, door purchases. This amounted to a loss of 17% of the value of door gold sold by the BOG. Losses accrued on gold trades are a combination of service and assay fees paid to Goldbod.
Yes, service and assay fees, 1.
Yes.
2.
Discounts on gold sold to off-takers, which is done by BOG.
Yes.
And most importantly, exchange rate losses from the spread between the Forex Bureau rate paid to purchase gold and the cedi reference rate used for BOG accounting.
This is your own document that you are referring to. The said IMF report that has generated these conversations. This is their own document they are referring to. If I come out as Goldbod, an institution, a separate corporate entity, and say, listen, these losses, even if they are not attributed to me. What is wrong in that? I should sit down for the losses. I have my own audited financial statement, 2025 audited financial. If you are speaking to that, then I can speak to it. In any case, the audited financial statement will be submitted to Parliament, and that will be the basis for which they will be queried. I do not know whether Parliament works with these IMF selected papers, and it becomes a basis for which they can interrogate, because the Constitution does not say so. So if the Goldbod comes and says that even when you read the report, it tells you that we were only an agent, and it breaks it down into three. If you look at it, it is purely an issue of agent-principal arrangement. The first one is fees, okay? I say fees and fees for the services that Goldbod PMMC provided in the period. What is an assay? Assay is basically chemical testing of gold to see the component of the gold and the quality of the gold. When Goldbod, who is the national assayer or PMMC slab, is doing that, they will need a reagent, they will need equipment. So if you say that we should buy the gold and test it for you, assay the gold for you, you would have to pay for that. You have to pay us a service fee for going around to mobilize the gold for you, for transport, for logistics, for security. And by the way, these fees and services were approved by Parliament for it to be charged. You pay to the institution. Then you say that that I have gone for a job, I have been appointed, those money that I have paid is rather loss on me, my books. I mean, what kind of bizarre arithmetic is this? What kind of bizarre accounting is this? Then the second one is discount on off-takers. Basically, the people that BOG sells to, they give them discounts, okay, so that they will be competitive. Discount only becomes controversial when it is so unreasonable. Even that one, it is BOG that must answer, because they are the ones that have the arrangements with those off-takers. And then the third one is the forex difference. You know, they buy it at the forex bureau rate. Yes, but when they are recording it, they use the BOG interbank rate, actually, and the account for differences. All of these are not attributable to that PMMC/Goldbod under the DGPP arrangement, but basically an arrangement with the Bank of Ghana, all right, who appointed them, have paid them fees that have been approved, okay? They have paid assay fees, they have, the forex differences was as a result of an agreement that had been made. There's a 2023 agreement that had been made as to how much it should be bought. It should be landing for me. Then you say that these differences are attributable to PMMC Goldbod. And by the way, the Goldbod itself, like I have indicated, have just started operations, and we have not edited the account yet. Right. What was edited was PMMC, and the specific model was the domestic gold purchase program as designed under the MPP. Goldbod, PMMC/Goldbod has every right, and they are actually right, both by their financial statement, by your own IMF report, to point to you that indeed these losses, we have not made losses on our books. Right. Then the bigger question of, so if you have not made losses on your books, where should the losses go? First of all, that is a shifting of argument. You say that Goldbod has made losses. Then they point to you that we have not made losses, and they are actually right. Then you say, okay, then the IMF has mentioned losses, and so somebody must answer to it. It is incumbent on you to summon the appropriate authority. And you see, like I began by saying, economic management, okay, is about making choices. And the BOG is a serious policy tool in the management of the economy. When the MPP got the chance, they decided that they will use the BOG to engineer hyperinflation of 54%. They decided that the BOG will sit down for CD to dollar rate to reach about 17 cedis, for our international reserves to be depleted, for a debt to GDP ratio to go up. The NDC wants to do it different. And the NDC, one of its main tools is the Goldbod, which is designed to help shore up our forex and help stabilize our economy. I'll come back to you. And it is the effect, and I'm landing, the effect of that is the low inflation. Is the low inflation we see. All right, it's the good. It is the good exchange
on the
that we see, and those things trickle down to the ordinary Ghanaian. That is why we are not at the projected 25 to $1 that they projected.
Okay,
and that is good policy initiative to use the BOG for.
My question is, why is this whole concentration on the cost of this and what not the benefit this is bringing to Ghanaians? Because this whole discussion, the press conference by the minority, the response by Sammy Gyamfi answering the questions, it looks like we are fixated on this 22 billion, but not looking at the social benefits or economic benefits of this program.
This is a classic case of the minority trying to set an agenda for the country. Classic case.
Yeah, powers.
But I'm asking myself, are we talking about the same IMF report that we discussed on this platform?
Yes.
The same IMF report. I thought the minority was talking about something else. Because the IMF, in their report, gave reasons why the losses arrived. And the minority is saying that they need a bipartisan committee to investigate this matter.
So IMF has become a political tool now.
What a waste of time.
That's not. It's the people that have decided to use it
as a political tool.
The IMF in their report outlined the reasons why the $1.7 billion, equivalent to 22 billion cedis, came about. And Alpha talked about it, the assay and other services. And you're asking for a committee to investigate what again? They just want to set an agenda to waste people's time. Because we know the reasons. And you see, the IMF in the earlier report said that this was a model. This was a model adopted under the gold program.
Yes. The Ghana domestic gold.
Yes, the domestic gold purchasing agreement, the program. This was a model adopted under the domestic gold purchasing program. A model, an economic model. So they decided to lose and gain.
And that's the nature of the model, actually.
That is in
fact, like Alpha said, the original PMMC BOG, it's one where you would make losses for some reason. One was for the reason, one was for the oil. So, like he said, the new Goldbod model now, they don't even need financing from BOG. They do their own financing.
Yeah. I'm saying that the IMF has said what you are saying. That this is a model, and they suggested that it is not sustainable. And we all sat, I remember, we all sat here, my brother KWAME, we all discussed this issue, that this model must be tweaked. And thank God, they had a meeting and they resolved that issue. So why is the minority taking us back? You see, sometimes I want us to be frank and speak truth to power. Sometimes some of the issues, they try to blow them out of proportion. This is no issue. We read it. We've discussed this IMF report here on this platform. Not once, not twice. But they just want to set an agenda for themselves. They want to get Ghanaians talking. But you see, surprisingly, Ghanaians didn't buy into the agenda. Why? You want a bipartisan committee to waste time and to even take from Ghanaians, the taxpayer, the money you are claiming that could be used to build hospitals and other things. You still want a committee to sit so that they will give them tea and biscuits out of the taxpayers' money. What are you talking about?
Don't do it for free. Don't drink any tea.
They'll bring tea from home if that's your concern.
And you ask a very important question. Why are they not thinking about or talking about the benefits that accrue to Ghanaians out of the losses? Because when you do the math, we are even gaining more from these losses. But you want us to focus on the losses. And you are leaving out the benefit that we are gaining. What kind of mathematics is that? And you are saying that somebody is doing voodoo mathematics and voodoo economics. Are you not doing voodoo analysis? So that we need to... And the thing is that when you hear them talk, you are listening to people whose regime also... whose regime supervised the same program that led to losses. Could you? Because when Alpha referred you to paragraph 13,
yeah, 400 million.
IMF in its own report said 400 million in 2024. They are leaving at the 400 million because they feel that it is insignificant, and they want to focus on this. But why are they not? Why were they not interested in looking at the causes?
And what was the result? What did we get from that?
And they knew the causes. They are aware that these are the reasons why we incur this cost or these losses. And you want a bipartisan committee to waste time, and you are telling people. And you see, and some of the commentaries, the commentaries are marking me, and that's why I agree with Kwame that this guy is going on board. That if someone will be slapped, or if an investigative institution will impose this hefty bail condition on somebody, or bail bond on somebody, then looking at 22 billion cedis, then yours will be unimaginable. What kind of comment is that? A senior political figure should have done better. When you descend into an arena of pedestrianism, somebody will also attack you. It was a pedestrian comment he made. So I'm saying that, and surprisingly, Afenyo Markin, a lawyer, was talking about a principal-agent relationship. Then he was saying that we should blame Goldbod, the agent. He was surprisingly, and when he decided to attack Goldbod, I didn't expect him to even dabble into that conversation of principal-agent relationship, because this one is legally grounded. And we know that if a principal duly authorizes an agent, whatever the agent does, the principal takes the blame. Unless the agent goes outside, yes, of the authority granted to him. So if Goldbod pay the transaction in case cost losses, who should bear the responsibility? You want the responsibility to sit on Goldbod's document. Why not IMF? Why not Bank of Ghana? Being the principal. So that conversation about principal agent, it shouldn't have dabbled into that conversation, because he lost the conversation from that moment. When he talked about principal agent relations, I said, this guy is gone. It's like hanging yourself in the neck. Nobody is hanging you. You just connect you just fix a rope and you hang yourself on it. You know what I mean? When I heard you, I said, Jesus Christ, what is this guy saying? A lawyer. So that conversation. So this is a classic case of the minority certain agenda which has failed.
Is it not the case, as the minority is making, that if the Goldbod in buying the gold on behalf of the BOG, because in instances some of the gold were even bought at spot price, what it means is that they were buying them at the price at which it's being sold on the international market. Yet when it's being sold by the BOG, it can be sold at a discounted price, which means that ab initio at that point you've even lost.
Yes, you've lost, yeah.
Is it not the case being made by the minority that the one who went to do the buying probably did not negotiate properly and buy at a rate that would give us money?
Could you have on this platform made it clear that when it comes to transactions, unless you can impute direct negligence, you can't say that someone deliberately incur costs. That's why you remember when the issue about some ministers buying public properties at a discounted price, I said, unless we are able to adduce evidence that in their transaction it was negligent, otherwise, an agreement between two people, that's the agreement. If Goldbod goes to the market to buy gold, and those who dug the gold out decided to sell it at this price, and Goldbod said, I'm buying it for you. Unless you can connect that Goldbod in buying it at that particular price, connive with the people. That is the market price they are selling it. And it fits into the broader conversation that I know. It's an economic model that will eventually lead to losses.
Right.
So this time around, and we are aware that in July they signed an MOU.
Yes.
Whereby now the government will be responsible. In fact, IMF, one of their suggestions
I don't know if you even mentioned it.
Exactly.
I think in the paragraph 14 and 15. Yeah, 14.
Yes, because
prospects for the
because IMF, even in the earlier report, suggested that Bank of Ghana should be taken out of the picture so that the government will cushion the losses. And that's what they have done. So I thought the minority will hold a press conference preferring suggestions that will move the conversation forward. But you want a committee, what for?
Okay.
It's a waste of time. Nobody should.
So before I go to Kwame and
that.
KOTIN, I just want to read a few comments to soften the tension, and I'll move on. So this is from Master Planner Junior. The fact of the matter is that 22 billion is gone. The NDC can call it operational cost, trading loss, or whatsoever. In reality and in conclusion, it is causing financial loss to the state. Whether it was Bank of Ghana or Goldbod caused the losses, someone must account for it. Just give time, some time. This is Hadi from Pig Farm. It is a deliberate communication plan by the Nagging People's Party to first of all then the image of lawyer Sammy Gyamfi, simply because they see him as the arrowhead that made them lose miserably in 2024. And also a well-rehearsed strategy to attack Goldbod and its activities, because Afenyomakin and his NPP realized Goldbod has been the backbone of this economy by making dollars available to BOG to stabilize the economy, making Honorable Atufosin's run of the economy far better than theirs. Afenyomakin and his NPP don't understand why the CD to dollar is not 17. Okay, so you go on. So thank you, Hadi. This also says, I'm listening to this topic now and I'm giving credit to all NDC people from President Mahama and Cabinet are doing very well. For my opinion, NDC, okay, you said something else. I wouldn't want to read this. If Sammy Gyamfi was speaking to Ghanaians, and for that matter, should he be, and for that matter, should be decorous? What stops Afenyomakin to also respect the citizens in his press conference, since it was not a banter in parliament debate? This is from Yamoha in Wa. I have quite a few. I'll read the last one, then I'll come in. Good morning, panelists of GTV. The only conclusion about MPP is that they thought Ghana belongs to them. So whatever they want to do, they will do it because Ghana is their own. This is Felix A.A. Kumase. Lawyer ISHAQ, this morning you're not getting a lot of love from our viewers. Kwame.
Yes, Master.
Now, again, I'll give a similar layman's analysis that I gave to Lawyer ISHAQ. I want to buy tomatoes. I can't go to the market.
Your Canadian accent has
I want to buy tomatoes. I want me to add the end. I want to buy tomatoes. Right. So I want to buy tomatoes and tomatoes. Now I can't go to the market.
Yes.
So I give my money to you, Kwame.
Yeah.
That go 1,000 Ghana cedis, go and buy tomatoes for me to come and sell.
Yeah.
I don't take into consideration that you bought the car. Mm-hmm. You will get Kaya Ye and the rest to carry. Mm-hmm. So you go, you buy all those things and you bring to me. Mm-hmm. Whatever you brought to me, let's say eventually it's 900 cedis because you use 100 cedis to cater for transportation. Mm-hmm. I decide to probably sit after a week, knowing very well that tomatoes are perishable goods. And I want to sell it next week, and I sell and I make about 700 cedis. Mm-hmm. And I come and I say that I should blame you for the loss because of how I traded. Yeah. I'm reading from a texter. Yeah. This one is not it's not me. Yeah. I'm reading from a texter who has done this paradoxical extrapolation. And this is how that person understands it. How would you let this person understand that what they are saying is or is not the reality?
Well, thank you for giving a layman's background to this whole
reading a layman's background.
Yeah, this whole unfortunate debacle that shouldn't have even started to begin with. The precursor, I guess, to this layman's view is why you KOJO asked me to buy the tomatoes for you. Why?
I want to go and sell.
Well, you may want to go and sell, but also you have noticed that you don't have tomatoes.
Okay.
And tomatoes will be sort of going out of the market, and you need tomatoes to be able to feed your people, right, or to feed your factory. So for instance, let's say you own a tomato factory. All right, and you're saying that, Kwame, I know that you have a direct relationship with the people who bring tomatoes from Burkina Faso. On the basis of that, I am asking you to go and purchase tomatoes for me. When you go, make sure that the tomato that you are buying is good, it's of good quality. You understand? I want to make sure that it doesn't have those spots on it. Make sure that everything is fine. This is the money I have, and I want this quantity. So go and buy for me, right? Now, like you rightly admitted, I'll take, I'll use transport to get there. When I go to the market, I may have to go to different market women to go and purchase the tomatoes. I have to make sure that when you check on it, everything is quality, blah, blah, blah. Then I'll bring it back, carry and all those things. You have to even wait whether it will meet the tonnage that you need, etc. All those things are part of the process of purchase, right? That is the understanding one must have when you are having a conversation about the Bank of Ghana PMMC, and I don't want to even bring Goldbod in, PMMC relationship. Bank of Ghana at the time in 2020 noticed that it didn't have a lot of international reserves, and that it did not have anything upon which the economy is built in order that our cedi can survive. So there were FX fluctuations, there were cedi fluctuations. The economy was in total tatters. So then how do we ensure that we introduce policies that will cushion our economy? And one of the things that came to mind was that, okay, then we have gold, right? So let's trade our gold. Let's find a way of using our gold to get FX in order that our international reserves will be strengthened, right? So they introduced what we call the domestic gold purchase program in 2020, 2021, thereabout. And in March, that program started. But you see, there's a child which was birthed by the domestic gold purchase program, which is the gold for oil. You see,
two children, gold for reserve, gold
for oil. So we must not decouple gold for oil and gold for reserves from the equation, from the mother. That is the domestic gold purchase program, right? Now, what is the program? The program essentially, like I indicated to you, if you read the IMF report, and I think people sometimes are very disingenuous and uncharitable to people who may not necessarily have the time to read, not because they don't want to, maybe the time to read. Let's go to the IMF report, and it will give you a better understanding of why even the program started. And that's why I decided to start from there, right? So, if you read the
which paragraph?
Just the first paragraph after the content, right? Lesson from the Bank of Ghana's domestic gold purchase program. You see, it didn't say lessons from Goldbod or PMMC's domestic. So the first point is that it is lessons from what? The Bank of Ghana's domestic gold purchase program. The selected issues, paper addresses, the legacy of the Bank of Ghana's domestic gold purchase program, again, makes reference to Bank of Ghana, which was announced in 2021 and mostly phased out by the end of June 2026. The paper examines how DGPP was instrumental in exporting 10.9 billion, which is 9.5% of GDP, in artisanal gold in 2025 alone. The rapid expansion of DGPP coincided and arguably contributed to a remarkable macroeconomic stabilization, but also large losses of about 1.7 billion USD, which is 1.5% of GDP in 2025. Lessons from the GDPP should inform future gold sector policies in Ghana, including Goldbod, which fully took over operations and costs of DGPP in July 2026. In July 2026. So I just want for the Ghanaian to understand that the genesis of the domestic gold purchase program was not introduced by any agent. It was introduced by the Bank of Ghana in order to what? In order that our currency can survive. That was the main reason why the domestic program was introduced, right? And I've told you that there are two children. You yourself even added the other child. Now, so what is the whole program about? The whole program is that, okay, we need reserves, right? So that our economy can be strong, so that we will use very little FX in our trading. So what we'll do is that we'll give the money to Alpha Company to go and buy gold on the market, because it is actually the regulator anyway. So go and buy gold and come and bring it to me. But even though you are going to buy the gold on my behalf, this is how much I have. So go and buy the gold at this price and bring it to me. Bear in mind that it was for a number of reasons. It was not because of profitability alone. In fact, at the time, the consideration was not of profit. The consideration was what? To cushion the economy. So at the time when the monies were disbursed so that we'll be able to get gold and then protect the currency. I just want to speak in very layman language so that everybody can understand. So they go to the mining companies, and you see it's two. Either the large scale mining companies or the artisanal small scale mining companies. Those were the mining firms which gave gold to PMMC / Goldbod if you want. So I'm giving you this money. Go and buy the gold for me. But you see, the price of gold is not determined domestically. The price of gold is determined by LBMA. So when you go to the mining companies and you are going to buy gold, the mining companies are aware. Listen, they are aware of the price of gold on the international market. So KOJO, even though you may, because of your policy, want to assume, or maybe you want the prices to come down, that determination is not made by you. It is made by the market. So you go and they say that an ounce of gold is, let's say, $10,000. The mining company will not sell to you for $9,000 because you are Bank of Ghana. Yeah. They will sell to you at the spot price, which is $10,000, right? And sometimes it is even very difficult, especially when you have a policy that does not align with their own, policy prescriptions. They sometimes even hoard the gold so that they will wait, and when the prices go up, then they sell. Do you understand what I'm saying? So you go and you buy. When you buy it for, let's say, 10 cedis, you, as the regulator, you are supposed to what? To assay, to make sure that it's of purity, and that it is one that you can bring back to the Bank of Ghana to say that the money that you give to me, this is the gold I have brought, it is of this purity because we are saying it is terror. Do you want the agent that went to buy the gold to use its own money to go and do the assaying? No. The Bank of Ghana, because you instructed, have to also give them money to be able to do the assaying. Now, the Bank of Ghana gives a certain amount, I think 0.something percent, 28 or so percent, right, of the amount, to say that 25% of the amount, to say that use the 0.25 to go and do that. Of course, that money has to come from the principal, right, the principal capital. That is also done. Now, when the prices, and like I said, the price of gold, the price always fluctuates. So Bank of Ghana even at one point may say that, okay, we have this tonnage of gold, right, but the international price has plummeted. So if we sell, they are even going to lose more. At some point, the price may also go up. So even though they may have bought it at $10,000, on a set date, it may go up to, let's say, $20,000. If they sold at that time, they will make $20,000. What I want here, this particular scenario, to teach us is that the fact that you have bought gold at a certain price and there are losses does not mean that it is actually real losses, because those losses can be catered for when you decide to sell the gold in the future. So I just want that fact also stated before I move on to the next.
Or the losses can even be further deepened if the prices of gold falls.
Brilliant. Thank you for that addition. So, like I said, it fluctuates. Now let me give people an insight into the operations of Goldbod, right? And we all understand why Goldbod was introduced. Goldbod was introduced to curb smuggling. Goldbod was introduced to ensure that whatever gold we send out, we actually get the true value of that gold. Because at a point, people were undervaluing. You recall that when NDC took over and did some audit, the quantity of gold that were exported did not match the books. So people were actually profiting from the lack of, if you like, compliance, if you like, within that space, because there was
actually even a report, I think, from the Arab Emirates indicating the amount of
gold that was
from Ghana. In fact, they imported from Ghana, and it didn't amount to what we say we had exported. There was a wide gap.
So that is what occasioned the policy shift. Goldbod operates a tiered system, right? So we have a tiered system for the purposes of gold purchase on behalf of the Bank of Ghana. And you see, because of how it is, it's difficult. I have had the opportunity of understanding them, so I know how difficult it is to even get gold to buy. So they have tier 1, tier 2, they have self-financing aggregator, and then they have the aggregators, right? The aggregators are sort of like the direct agents of Goldbod, because Sammy Gyamfi cannot go to the field to go and buy gold. So they also have what? Agents. So the the aggregator aggregates the gold for and on behalf of Goldbod for the benefit of Bank of Ghana. That is number one. So you need to understand that. Now, Goldbod has to also finance the aggregator to be able to go onto the field and bring the gold. Then we have the self-financing aggregator. The self-financing aggregator, they use their own money. So there is no direct relationship between the self-financing aggregator and the aggregator, right? Even though when they all aggregate, they can decide to sell to Goldbod. So the self-financing aggregator can do two things. One, they can decide to sell directly to off-takers through Goldbod, or they sell directly to what? To Goldbod. And of course, when Goldbod aggregates, they aggregate on behalf of what? Bank of Ghana. Then the tier ones are the ones who are on the field. The mining company, they will go and buy the gold either at spot prices or whatever, but they sometimes incentivize even the people who have to sell because of how Goldbod came and changed the whole trading activities within the mining communities. People hoard, so you have to incentivize people to even sell the gold to you. Are you following? Then the tier ones now sell to tier twos. The tier twos are the ones who also now aggregate and then will be able to sell to the self-financing aggregators or the aggregators of Goldbod. That is how the model operates. Now, within that process, if, for instance, and I've had the opportunity of representing one of the self-financing aggregators, the firms. So what happens is that the off-taker will write a letter to the self-financing aggregator, and this here I'm making a specific reference to the self-financing aggregator, so that you will marry the two and know why Bank of Ghana's losses is not deliberate. So let's say Powers is in Dubai. Powers wants to buy gold from Ghana. Powers knows that KWAME also has a self-financing aggregating license, so I can aggregate and sell. Now the model is such that Powers cannot directly, KWAME also cannot directly send gold outside of the jurisdiction. It has to go through Goldbod. So Powers will write to me, the self-financing aggregator, expressing his interest to purchase gold from me, because I also have the license to do that. Then I will write to Goldbod and tell Goldbod that there's a certain BRAKO-POWERS who has expressed interest in buying gold from me, so that Goldbod will now do what we call due diligence. They do due diligence. They do one for money laundering. Then they do one for terrorism and financing, right? So when they clear that off-taker, then I will now write to the off-taker to say that now I can sell the gold to you. But you cannot send the money to me directly. You send it through Goldbod, and then Goldbod will give me that money. So if you send $20,000, and at the time the exchange rate was, let's say, 15 Ghana cedis, right? They will give you 15 Ghana cedis worth of the $20,000 that you've sent. Now, what happens is that within that space, you are supposed to buy, maybe the $20,000 will buy, let's say, 20 kgs of gold, right? Now, so the money is supposed, so you, Powers is expecting 20 kgs. But the money will come to Ghana, and the moment the money gets to Ghana, you see that your cedi has what? Has depreciated. When the cedi depreciates, you will not get the $20,000 worth. So what I have now will become, let's say, $15,000. So when I go and I'm buying, I cannot buy $20,000 because I don't have that $5,000 because of the cedi depreciation. I'll go onto the field and then buy what? $15,000. And that is what I will send to the off-taker. It is not because I have chopped Powers' money. It is because the currency fluctuated at the point when I got the money, the currency differentiation. And that is what Goldbod is trying to highlight. That you may give me money to go and buy gold, but at the time when I'm going to buy the gold, the currency may have depreciated, and therefore I will not be able to to sell or to get the gold, the quality or the quantity that you want. Okay. And that is what I want stated. Right. And in concluding, because I know you want to move.
Yes, because I need to get.
You see, Sammy Gyamfi made a statement, and I believe we are all glossing over that statement. For me, it was one of the profoundest statements made, but clothed in, if you like, in diplomacy. He said that he will not give way to extortionists. Listen, read that thing carefully. Today, Parliament has become a marketplace. Parliament has become a marketplace. People do deals. They want to cut deals. Those days are over. That you see, whenever you see a report and you think in your mind's eye, you want to assume that a certain wrong has occasion, then they use that to do barter trade.
Okay.
Sammy Gyamfi is telling. That's what they do. Hold on. Oh, please, don't do this to me. I just want to conclude that.
Okay, so conclude on that.
Let me land well. Let me land well. I am saying that Afenyo Makin is notoriously known for doing those deals. And I'm saying that those hold on. If he's allowed to insult judges, why am I not allowed to speak my mind?
Not on this platform. Not this platform. I beg you.
What is
I am responsible for this platform. I beg you. KOTIN. You two hold on. Kwame, hold on.
When you do this, you are rather imputing things.
No, Kwame.
No, when you do this, you are creating the impression that I've made a statement that is on top.
Kwame, hold on.
I am saying that the gentleman, I'm making a direct reference to a statement that was made by Sammy Gyamfi. Can't I refer to that statement?
You are saying that Sammy Gyamfi made a statement that they are not going to entertain extortion.
Yes.
Then right after that statement, you are saying that Afenyo Makin, you mentioned something about Parliament.
Yes.
Okay. Then right after that one, you are saying that Afenyo Makin is notoriously noted for this.
Yes.
So you are linking this. That means he's notoriously noted for the extortion. That's the point I'm saying. You can't say it on this. I don't have evidence to support that.
Who was Sammy Gyamfi
I don't know. I don't know.
But who is the one who alleged these malpractices against Sammy?
Minority.
So which minority? Who is the man? Okay, the minority is notoriously known for this. What is the meaning of that? When you do this, I'm also a journalist. When you do this, you are imputing things. Let me make a statement. If I had landed, you would have understood what I was saying.
You couldn't, please.
Well, KOJO, thank you. In fact, on Wednesday, I had the opportunity to do an academic exercise on GTV morning show. What many people don't know is I study economics, right? You see, Goldbod is not a new creation.
I know why you don't want me to talk about it.
Goldbod is not a new creation. It's only PMMC has been transformed into Goldbod to cure an economic challenge you face as a country. Now, if you look at history of this country, Bank of Ghana has always incurred losses in our gold trade activities. It's nothing new. It's nothing new. Now, this IMF report we have all read, and we did fact checking. There is nowhere in the report the IMF says that Goldbod has incurred those losses. Yep. When we did the fact check, it's a BOG. So now, Afenyo Makin's initial statement was that Goldbod had made losses. Now he's shifting it to the point that there are losses he admits, and BOG incurred those losses. So Goldbod must be responsible for those losses. What kind of logic can that be? You see, we are doing politics of dishonesty, and that is not good, because if we begin to defend anything, whether it is good or wrong, depending on the political aisle we are sitting, we will not be helping this country, by extension building our institution. Let's decode Afenyo Makin's press statement vis-a-vis what Sammy Gyamfi's response were. And you hit the nail where I wanted to start, except that you went too deep. Afenyo Makin is a lawyer. He is somebody who doesn't joke with his image and integrity. Someone has impugned on your integrity that you are an extortionist. In response to those, Afenyo Makin kept quiet on that. What is it that is in there that we don't know? We want to know. You remember in Parliament, when some MPs were not happy with Ken Oforiatta, and they made noise for Oforiatta to go, there was an allegation of a businessman who brought money to sort out those parliamentarians. Yet, integrity and corruption-related institutions are not interested in making sure that these allegations are investigated and proven. You see that they are becoming one too many now. Now, let's go to why we are where we are. 2024, did we make losses in our good for oil purchase or we didn't?
We did.
About $400 and something dollars, $1 million. How much gold were we able to bring on board at that time? Just oppose that and look at the quantum of gold we are talking about today and the losses and the reference. You see that we'll be so insincere to ourselves more often than not, the kind of thing we throw into the public. Goldbod is the creation of parliament. Is that not the case? Where is the public accounts committee? Why is Afenyo Maki not interested in bringing Goldbod to the public account committee to answer to the allegations therein and want a presser? I can see you people are singing. You are going. It's not been fair to me.
Talk. I've not said it. I'm in front of you. I've not said anything.
So look at it. Look at this. I have done I've done an activity and I've carried a loss of $1.7 billion. But I brought a revenue stream of $10.8 billion. Why are we not talking about that?
Maybe we would have gotten more. Just subtract 1.7.
Exactly. And you see, we are talking about losses. You see, equity matters. So sometimes the message may be good, but the messenger is not credible. When Afenyo Makin was the board chair of Ghana Water, how much losses did he make? When he came to ECG, how much losses did he make? So sometimes we are cheapening our political discourse, and it has international reputations. And you see, I just want us to look at something. Look at our gold reserves. When MPP left power, it was 9-point-something tons. Is that not it? What is the current gold reserve we have? 14-point-something tons. More than half of what? In 1.5 years. And Ghana is now the 6th largest producer of gold. So what are we talking about?
I know, Lawyer ISHAQ, I know you want to, but there's a paid for live program at 10 o'clock. So I need to go, Lawyer ISHAQ.
Then I'm not finished. Then you better be fair to me.
Yes, if I allow you, I need to allow Lawyer ISHAQ. No, Lawyer ISHAQ, what I promise is next week I'll allow you. Okay.
Agenda was brought to you by Bank of Africa, the African bank with global reach. Bank of Africa, as strong as a group, as close as a partner. And National Petroleum Authority, NPA, where customer care meets excellence.